Page number 1, item number 1 to 4. Page number 2, item number 5 to 13. Page 3, item 14 to 20.
Item 14, well, item 17.
Yes.
The matter squarely covered by that.
You, Mr. Mukherjee, is that somehow you come at 12, right on 12. All right. And he is appealing to the state in the matter?
Yes, I am.
Check.
Copy of that.
Just early, now, right now, you check up the
Already.
Pardon, Your Lordship, item 12, Your Lordship.
Just a minute, let the paper, item 12 also you want adjournment.
My Lord.
When?
I need to September only, Your Lordship.
Has it come on mention? No, notice could not. No. Item 12.
My Lord, item 12.
You have
You have
not
to requisites. What adjournment? That when
You have not filed the requisites.
it reaches to that already.
and returnable date lapsed, so let it be.
Next week, anytime, Mr. Services.
Just wait, we pass the order.
Lordship.
If not pass any adverse order, you will direct you to take the steps
Your Lordship.
for purpose of service of notice on this respondents number 5 to 9. Yes.
Page 4, item number 21 to 25. Page number 8, item 26 and 27. Page 9, item 28 and 29. Page 17, item 30. Page number 47, item 31 to 35. Page 48, item 36. Page 49, item 37 to 40.
Item 14. This is similar to item 13. This is arrest scheme appointment. Maybe taken up with item 13. Both 40, 41, both.
Both 40 and 30.
Okay.
Page 50, item 42 to 44. Page 51, item 45 to 48.
May I please, Lordship? Lordship, item 48, the counter affidavit filed by OPI 3, we received the copy a day before yesterday only. Lordship, we pay for 3 weeks' time to take the instruction and file the rejoinder in this matter.
48.
48, my lord.
Request to Mr. SS, but you are on record.
Yes, my lord.
Yes, look at the last one.
Yes.
The order has not been uploaded, the last order. I remember we passed
It is
the order
uploaded, my lord.
that he will file counter affidavit. Mr. D. Mahapatra had taken for time. Order has been
On
filed.
28.
The counter affidavit has been filed.
Counter affidavit is already filed by IRERA.
No, that day Mr. D. Mahapatra had taken time stating that on the last date, he had undertaken to file in the course of the day. So that had not been filed. He had stated he would file. That order is not there. That's why I'm asking whether it is there on record and not scanned or what is the problem.
Not scanned.
But it's there.
Not 28 August. 28 August order.
Also, what is there?
48.
Because the order in the month of July 1st that you will file the rejoinder because they did not file the counter
Yes, madam.
affidavit. So it will come on the 9th of October.
Bless my.
The request of Mr. SS Tripathi and counsel appearing for the petitioner that the matter be listed on 9th of October 2023. So at the request of, in the meanwhile, the rejoinder, if any, may be filed by the petitioner. No further accommodation will be made for the purpose.
Yes, ma'am. Interim order to
Mr.
confirm, my lord.
Mohanty, yes, interim order is passed earlier, shall continue. Mr. D. Mahapatra, Mr. Mahapatra is here? No.
No, I am appealing for the Mr. Vibhu Prasad Tripathi. He is for opposite part number 3.
Orera.
They have filed the counter.
Yes, he has filed the.
You are appearing on instruction of Mr. BP Tripathi?
No, I am for opposite partner wanted to state.
On behalf of Mr. BP Tripathi.
You are there.
Fine.
All right. Have you filed the counter?
Yes, they have filed.
On record.
That is, I think counter is there, no?
No, not there. Notice this counter.
Registry is directly is the counter affidavit on record. Mr. D.K. Mohanty, learned additional government advocate, appears for the opposite party number 1 and 2. And your good name, sir?
Narayan Bari. Narayan Bari.
Mr. Narayan Bari, learned counsel, appears in you are on record
No.
on instruction of Mr. B.P. Tripathi, learned counsel, appearing for the opposite party number 3.
Deeply obliged, my lord.
Pardon to make a mention, Madam, 43. I'm sorry, I just missed.
All right.
43, your lordship has given me liberation at 12 o'clock. And I informed the opposite party to even present, my lord. 12 o'clock, there is the election dispute. Yesterday I had met him.
Oh, all right.
That
So, Mark.
Inform for the said.
Next.
Page 52, item 49 to 52. It's over there.
All right.
memo I filed blood. This is WPCRL 64-22. Last occasion, the matter listed here, it could not listed. But the erased blood, but this matter, a minor child has been kidnapped. That has been 1 year is going to be completed. Last week, I think.
Have you forgotten about the case? Suddenly you remembered, it seems.
Already we're just taking up. What is your
My lord, my number is the serial number 78/23. It was listed 22 August 2003, but matter was not listed that same day. But it was urgent one dated 10th October 2023. My lord, victim is not victim girl is not recovery by the police. My lord.
October?
No. When was it supposed to be listed?
And 22 August 2023. But it was urgent on 10th October 23.
Huh?
That must say.
No, so all right, but it is a habeas corpus matter.
Object.
Give the
10th October.
Make it in the next week. It will come.
It's a case, it's a read appeal, my lords, case of regulation, my lords. Your lordship was specifically directed the matter to be taken up yesterday, my lord. In her bid, the matter was not taken, not been listed.
Give this memo.
Actually, list on topic number 627 of 2022. Petitioner is illegal. Respondent is illegal. His locker is seized by the cooperative bank, Balasar Cooperative Bank Society, and 2 years has already gone. That is the possibility.
That will be checked already.
16 applications.
Date has been given on 16.
Yesterday I can list, my lord.
All right.
The levy is locker is seized. Criminal case.
All right. Let us see. Let us see. It is very difficult to prepone all the matters.
To review applications, my lord, it was disposed of by Honorable Chief Justice and Honorable Justice C.R. Das, my lord, for review application.
What date was it disposed of?
It was disposed of on 22/10/2022.
So you have waited for almost 1 year.
My lord.
All right. Let us see.
I don't
Anyway, we are not giving specific date. We will be asking the registry to expedite the listing of the matter.
Lordship, WBC number 17780/2023. The Lordship has fixed today, but no matter could not be listed. Lordship, similar matter, item number 50. That matter may be tagged up with item number 50.
In the file and public notice 150.
Pardon
Hello, you were there?
to make
And when the item number 50 will be called out, you just remind us again
Yes, Lordship.
and inform the council who is appearing for the opposite parties.
Of government, Mr. Khompia was appearing.
This is
Six is there.
huh?
Noting is defect number 6 is there. Copy has not been sought on state.
He's saying it is not
That
there in the
different
list.
matter.
Item 50.
Similar mattering for 50. He says this the item he is mentioning
Yes.
is similar to item number 50.
Yes, Lordship.
And keep the numbers.
Just you give the number to Mr. Mudali.
Sorry, pardon to make a
Sleep. Mr. Counsel, don't use this kind of a slip. You come with a memorandum when the matter is not listed, because it will be put in the official record. It is out of list, we will be going to list the matter.
Sorry to not mention this. It's a old criminal appeal. Matter is of 2014. On 22, the petitioner granted bail. But on 3/7 during course of hearing, the counsel for the petitioner withdrew the wakalatnama. That's why he is again taken into custody. So we kindly list it tomorrow.
Please check up. Tomorrow is not possible. We'll check up earliest listing will be considering.
My lord, read appeal number 605/23. That is posted to 19th July to 28/8, but not listed on the date.
So we just find out. Give me
No. May I be permitted to mention WPC number 2721 of 23? The lordships had pronounced the judgment on 27th of June 23, but it has not been uploaded.
Already look into the matter.
Dear Lordship, I'm just handing over.
I will mention, my lords, this item relating to this WPC 2387 of 2022, Indian Disturbing
Chamber.
this matter leads to additional fee under the motivation letter. That's a big petitions are there. It was listed on 23rd August. There, the money given date 3 or 3rd October. Let's hear this matter next week.
We cannot say next week, give that we'll look into the matter and try to prepone the list. Just take it.
Can I seek Lordship's kind indulgence? A writ appeal which was specifically adjourned to today, your Lordship has not been listed.
Already will be listed day after tomorrow.
My Lordship. Much obliged.
Lordship, this matter assigned to Honorable Single Judge Lordship, and I had taken liberty to move your dear Lordship. And perhaps last 7 days, every day my associate is approaching you, dear, it is not coming, urgent matter, Lordship. You come.
Take this way. I think it should be by the administrative side, they say come. What happened is some,
I don't to study currently.
just say.
May I call the list? Supplemental list, first additional item for one. Please, your Lordship.
In this case, list of dates, taxations and written notes. And for the contesting list, number 2 and 3.
Yes, Mr.
Friend is, even before I open my case, I believe a notice is warranted and the assembly is to be heard.
Well, I am on caveat, Your Lordship.
All right, just all right. We are not.
My difficulty is, my lord.
No, because allow Mr. Mukhtar to submit the submission. Yes.
Page 115 of the brief is the operating portion of the judgments. About 10 lines, 8 lines from the bottom of the page, sentence beginning accordingly this court directs.
Paragraph?
This is a very long paragraph at page, it's paragraph 49. It begins at page 114. That's internal page 48. I am inviting your Lordship's attention to page 49, internal page 49, page 115 of the brief.
Yes.
About 8 lines from the bottom of the page, sentence beginning accordingly this court. Your Lordships have that?
Yes, yes.
Accordingly, this court directs the opposite party number 1 to immediately convene a meeting of the selection board in terms of Rule 7.2 of the Rules 1983. The name of the selected candidates which were uploaded in the website of Orissa Legislative Assembly dated 28/21 be placed before such selection board. Thereafter, necessary action be taken by the opposite party number 1 pursuant to the decision of the selection board and the honorable speaker within a period of 8 weeks from the date of communication of this copy of this judgment. Now, this worked out, my lords. And in the meantime, what had happened is we had filed an appeal against the judgment, and my lords, the assembly had also filed an appeal. But what happened was when it went before the selection committee has decided to scratch that list. And advertise for selection again. And that has been approved by the governor. Now, thereafter, what has happened is, my learned friend's client has again approved this honorable court against the decision of the selection committee. So, my lords, in fact, it's more or less for implementation or enforcement of this order, which another petition has been filed. So that is before the learned single judge now. And if that, so it will have a bearing on that. So I pray that this matter has to await the decision of that, or it may be decided and that matter be stayed.
Totally different footing, may I for a moment.
Yes.
2 writ applications were filed. One by the present respondent number 2 and 3. 7 posts were advertised for post of reporter before the Orissa Legislative Assembly.
Yes.
The respondent number 2 and 3 were selected and put up in a final select list. The present appellant, my lord, he was rejected, my lord. He is a failed candidate. He filed a separate writ application, arraying the respondent number 2 as opposite party number 2 and 3. There, my lord, his whole plea was based on a written note of dissent that the selection procedure is vitiated because of an alleged note of dissent. That is why the selection should be cancelled. The Honorable Single Judge, my lord, called for the entire records and found that, in fact, there is no written note of dissent. I filed an RTO application in the Legislative Assembly, and there they told that no such written note of dissent exists, my lord. And there is a categorical finding. I will show, my lord, 2 different counter affidavits were filed by the Legislative Assembly. In my case, they filed a counter affidavit saying that everything is all right, there is no vitiation of the selection process. The writ petition is premature because the selection process is not complete, and as per Rule 7.2 of the Legislative Assembly rules, the selection board is there to sit and pass final orders. So thereafter, the Honorable Single Judge, but both the writ applications were taken up together. I took 2 pleas, my lord. One, my lord, that a failed candidate who has taken part in the selection process has no right to challenge it. Secondly, a person, my lord, the legend appellant belongs to SAVITri category, my lord. The respondent number 2 and 3 belong to different categories. One is to SC and another is general. I filed a judgment of the Honorable Appellate Court stating that a person belonging to a different category has no right to challenge my selection, my lord. So those 2 grounds, my lord, were not dealt with by the single judge because he went into the merits of the matter.
But the subsequent event actually made this present to the writ appeals. I do not know whether you have filed the appeals or not.
Thereafter, my lord, the writ appeal was filed against that common judgment.
Yes.
In between, they passed the order cancelling my selection on the ground.
That is what Mr. Mukherjee is pointing out.
Now, what is my lord? Now, this writ appeal is hanging like a sword of Damocles before me. Because, my lord, suppose tomorrow the single judge is giving me liberty, that in case they go for fresh advertisement, I can put up the matter for appropriate orders. Now, because of the tendency of this writ appeal, the single judge may not pass any orders on that, because what Mr. Mukherjee is saying, Legislative Assembly will say that in the second round. Mr. Mukherjee is not a party in the second round of litigation, my lord. So he is not affected by what will happen there. Whatever order your lordship is going to pass, and what is his prayer, my lord? Was the order of 1923 common order and go for fresh election. So, my lord, I have a right when I file another writ application. And why the single judge allowed? There is a 3-judge bench of the Honorable Apex Court has said that a person has not a right of selection being in a select list. But certainly, the government has a right to inform him why they should not select him if there is a vacancy. Because
the question was raised, I understand something different. Their contention was totally based on the note of dissent that was given with some of the members, 3 members of the selection committee, giving their reasons why they are objecting to the selection process. According to them, the entire selection process was unfair.
Yes, that is that.
So the unfair selection process can be questioned at any time by any of the candidates who participated in the process.
That is why I am talking about judgment called for the original records and found that there was no note of dissent. It gave a categorical finding, my lord. The original records were called for. And 2 different counter affidavits are filed. In the first counter affidavit where I was a writ petitioner, that plea was never raised. Subsequently, my lord.
Now, suppose, all right, suppose we hear the matter and decide the matter right now.
Yes.
What the court will decide? What the court will decide? Because that cancellation of the inter-selection process is not the question before us. It has been not challenged by any proceeding before this division bench.
Yes, yes.
You are
Yes, the prayer, man.
What is the prayer? You have challenged the order of the cancellation by the selection.
They have said,
Yes, sir.
no, kindly see that, my lord, I show man.
What is your appeal? What is that appeal number?
My lord,
Here what said.
no, in this appeal, kindly see what is their prayer, my lord.
What
No, no,
the
first
judgment?
come to that question that I have asked you. That the selection committee has recommended for the cancellation of the entire selection process.
Yes, it has been cancelled.
And it has been cancelled by the Orissa Legislative Assembly.
Selection board, my lord.
So in that, for that development, all these challenges virtually become infructuous unless that order, the cancelling the selection order is stayed by the court. Whether a single judge has stayed that order.
Single judge, my lord, when the Orissa Legislative Assembly Council appeared, I had filed a miscase for stay. He made a submission that no advertisement has been made, and I was given liberty by the honorable single judge that in the event they go for fresh advertisement, you file a case for miscase for stay and you get it listed. It is pending at that stage. So my lord may kindly appreciate.
No, but because there is no stay orders.
No.
Don't just request us to go into the merit of that case, we will not go. No, just wait, Mr. We will not go, and we are supposed to not take notice unless you are mentioning the matter before us in the proceeding that this thing has happened. There is no affidavit in these appeals that this has happened after filing of this appeal. A written note is not a part of the proceeding. It is only
Respondent, I cannot file an affidavit. I can only.
Who says that you cannot file an affidavit? What is that law? The respondent cannot file affidavit?
Well, because
Notice has not been.
this is the retroactive.
This is you have filed an affidavit for bringing the subsequent events for knowledge of the court, so that it can be put into the record.
I have in my written note, I have not filed an affidavit.
You file an affidavit because written note is written note. It has to be brought on record.
That is my only anxiety, my lord, for early disposal in the sense.
But we cannot decide anything now. I am telling you. Simply we'll note that this has happened, and therefore there is nothing left to be decided in these two appeals.
The other appeal was withdrawn exactly on these premises.
Yes.
That the selection thereafter, my lords, he went and filed the petition. Had the Legislative Assembly known that a petition has been filed by him, they would not have withdrawn the appeal.
But it was image within the knowledge, my lord. My lord, what has happened when they filed the writ appeal and when the matter was taken up, they took a plea before your lordship. We are going to pass final orders. Your lordship has done it to 4/8/2023. And in the meantime, they passed an order. No, we are cancelling it. And they have taken the grounds which was specifically referred by the honorable single judge. That there is a note of dissent, that there is a no PUT in the reproduction process. There is a specific finding. I can point out just now, your lordship.
Just wait also.
Of course, another aspect pending before the single judge. But only
Pending before the single judge on a different cause. It is a completely on different cause. Single judge will examine the legality of the cancellation.
that is the subsequent events which has happened.
That is why, Mr. Mishra, that what will decide in this appeal?
My lord, may kindly see.
My lord,
My lord, may kindly turn to page 113 for a moment. What the single judge has recorded after calling for the records.
No, just don't bring that fact. These facts are known to us.
My lord.
You have at least 5 times you have repeated the same. The single judge did not find any note of dissent in the record. You are again bringing us that. Yes, sir, yes.
In 3-4 paragraphs, my lord, he has specifically stated.
All right, we have seen. But after that, what has happened? That the entire selection process has been cancelled.
My lord, he gave a direction to the selection board to consider that as there is no written note of dissent, there is nothing wrong in the selection process. It has been done properly. Because there is a rule 7.2 where the selection board has to ultimately sit on the final selection list and pass an order.
Mr. Mishra, that thing which you are referring to, the single judge has said, so far the present case is concerned, the record does not reveal any irregularity or illegality. On the contrary, a note of dissent has been referred to in the note sheet. Whereas the said note of dissent was neither produced before this court, nor the same is available on record. So there was a reference to that. That is why on that plea probably they were.
Yes, thereafter you will also see.
Other than such allegation, there is no materials which would impeach the fairness and transparency of selection process, which is in fact was sought to be defended by filing the counter affidavit.
Then another line I make, my lord. Although a different counter affidavit has been filed in WPC number 6171/2022. That is in
So in your petition, they were defending that note of dissent.
No note of dissent was ever filed.
So what do you mean by different? Different is different documents or different in tone and nature?
What had happened in my counter affidavit, they told that my writ application is premature because the selection board is yet to sit.
All right.
But in the second writ application for the first time, they supported the present appellant and said, yes, there is a note of dissent, it should be cancelled.
All right.
So that was what was recorded. If you lordship will see para 25 single judges recorded that a different counter affidavit was filed, which is different from the one filed in the earlier writ. So that is why the single judge called for the records to see for himself what was the truth behind all these things.
No, that is the question, that in view of the subsequent. The problem is the appellant in the present case. He has challenged certain things. I think why you are not doing that thing with liberty to contest the
because its finding of the learned single judge that there is no note of dissent is to be assailed, my lord. That finding will create a problem for all for the ultimate cancellation of the.
When the cancel, it has been cancelled. Yes.
Now, again, in turn, what he is doing is he is again in turn challenging it with the petition, saying that once this honorable single judge has said that there is the selection is vitiated, so there is nothing wrong in the selection, and that has to be upheld. How could it be cancelled? That is what he is questioning.
He is challenging the cancellation, I understand.
Mukherjee, without entering into the merit,
Yes,
because in the subsequent event that has been disclosed to us,
yes,
if you say that your right to raise objection regarding the existence of different road is protected by this court to read in the proceeding before the learned single judge, I think you are
In the first writ application, he filed an intervention petition.
Mr. Mishra, wait.
The writ appeal is allowed to intervene, my lord.
Not writ appeal, writ petition.
Petition that you have filed.
Yes, if that order is passed, my lord, I'll be.
Mr. Mishra, how can you have it both ways?
How will be prejudiced? No, first concentrate your argument, how will be prejudiced?
Because, my lord, the single judge has found categorically his only defense on merits was the note of dissent.
You just see the records.
Then, Mr. Mishra, then we have to entertain this writ appeal to examine if that finding is correct or not.
Just see the records. The records are before us.
So both ways, how can you have it?
This is the very document which was never produced. The original was never
Exactly. Now they are producing it before us.
produced. The original, who is producing the
This is RTI application.
RTO application. Disclosed it. Are you telling me?
My kindly see, in his writ application, when Legislative Assembly filed a counter affidavit, in his support, I was given liberty by the Honorable.
But in a another writ petition, Legislative Assembly filed another counter if it is stated, yes, there is a note of dissent.
Madam, kindly see, under RTI Act, I had filed one counter affidavit to opposite party number 1, that is 6/2/23. There under RTI I had asked whether any note of dissent was received by the OLA secretariat given by the examination committee. If each date on which it was received, date on which was entered in diary register. The reply was, with regard to the information sought for at item number 1, 2, and 3 above, it may be submitted that the note of dissent was neither received in the office establishment branch nor available in the branch. This is of 22.
They have correctly disclosed that. There is no dispute about that because the dissent of note cannot be supplied in the receipt section or the department. It will be put to the chairman of the selection committee because it is a confidential procedure. They are right in their way.
Establishment
No, sorry.
is the repository of the records of the legislature.
No, sorry, Mr. All records doesn't go to the establishment section. There are confidential section also.
But even thereafter, the entire selection proceedings were called for and it was not found. And they are the interpret stage, produce a Xerox copy, my lord.
This is not It is not, it is a disclosure by RTI yet,
By whom, my lord?
by the authority, RTI, the state.
My lord, that was never part of the pleadings before the single judge. Yes, kindly.
Page 21 of the brief. Page 21.
Let's come to the page 21. This is a part of the writ petition, I believe.
Yes, yes.
My lord, they say that we were not provided these documents. That is their pleading. They applied under RTI. That document was not given to them. How they are now producing, I don't know. My lord.
Is where
That the OLA will say.
My lord, kindly see paragraph 8 at page 18. That it is humbly submitted that the petitioner has categorically called for the recent note of the members of the selection committee to the selection, but that was not supplied to him.
so far,
My lord, so far in the sense till disposal of the writ application.
maybe,
Till disposal of the writ application, it was not produced.
yes.
It was not produced when the original documents were proposed. There is a categorical.
Do one thing. Just file an affidavit.
I'll do that.
That when you have received it, yes, method of receipt, that is considered. Let the matter be listed on 11th of September 2023. Meanwhile, the appellant is permitted to file the affidavit regarding the disclosure as to the dissent note in the selection process. Before filing the affidavit, a copy in advance be supplied to the Land Council, appearing for
Respondent number 2.
respondent number 2, both
2 and 3.
2 and 3. Also to the council of the respondents.
Hello, respondent number 1, Mr. Palik is also appearing. May I pray that let him serve copy upon him also.
No, I've said all the respondents, council of the respondents.
My lord, the appeal memo also, my lord, I was playing. Because
You have not,
Mr. Palik is now appearing in the subsequent writ. In this.
all right, you will check up with Mr. Palit.
Yes, let him also that, my lord, he may say what.
Because Mr. Palit may not have any interest anymore in the matter. Because if Mr. Palit likes to appear, supply a copy, never.
I'll do that. I'll do that.
Supply.
All right. And also bring the subsequent fact of cancellation.
I will bring, my affidavit, I will bring all those files.
And subsequent development that has taken place at the filing of the writ appeal. Yes.
Item number 2.
Your lordships posed a question to me yesterday,
Yes.
whether the Tahsildar has the jurisdiction to reject the caste certificate. My lord, I've examined the Odisha caste certificate, scheduled caste, scheduled tribe rules 1980, and there is a 2011 act. Under the provisions of the rules and the act, the Tahsildar is the issuing authority. And when an application is made to the Tahsildar, he may issue the certificate or reject the application by recording reasons. The jurisdiction of the SLSC, the scrutiny committee, comes at the stage of verification. If a complaint is received or if a reference is made regarding genuineness of a certificate, then the jurisdiction of the SLSC steps in after issuance of the certificate.
Yes.
In the present case, no certificate has been issued till now.
Okay.
The Tahsildar has rejected the application for issuance of certificate.
Okay. Who is appearing to the appellant?
I'm up.
Yes, make a submission.
Your Lordship. Well, the learned single,
Can you give the reference of this book?
Your Lordship. Well, I'm handing over a copy of the statute. This is not there in that book.
This is the Odisha caste certificate for SC and ST rules 1980. You are free.
That is at page 53 of that book, Your Lordship.
All right, that's all.
Sir.
Yes. Yes, Mr.
Page 53 is the rules, Your Lordship.
I got it.
Rule 3 is the applicability. A certificate issued by the competent authority under these rules shall be accepted by the appointing authorities in relation to a service or a post in an establishment.
All right.
Then Your Lordship, I see Rule 5.
In order that certificates are issued to the serving persons, it is necessary that proper verification based primarily on revenue records and if need be through reliable enquiries is made before issuance of certificates. Provided that in case of doubt of the competent authority about the case of the person, the competent authority may conduct local inquiry and take appropriate steps to issue the caste certificate without delay within the prescribed time. And if your lordship sees competent authority definition at rule 6
Yes.
Sub-rule 5 includes revenue officers not below the rank of Tahsildar or additional Tahsildars.
Yes.
And if your lordship sees the statute is subsequent, has been issued past 2011. Competent. Section 2, Clause D defines competent authority. Competent authority means an officer or authority authorized by the government by notification to issue caste certificate for such area or for such purposes as may be specified in the said notification and shall include all the competent authorities already designated by the government before commencement of this act having jurisdiction over the area or place to which the applicant originally belongs unless specified otherwise. Therefore, it includes the competent authorities under the 1980 rules. Section 3 is the application provision. Any person belonging to any of the reserved category required to produce a caste certificate in order to claim the benefit of any reservation provided to such reserved category.
No, that's for application of the certificate.
4 is the provision for the competent authority to either issue or to reject by giving reasons to be recorded in writing.
Yes.
Section 5, there is an appeal provision. And section 6 is the jurisdiction of the scrutiny committee.
Have you appointed the...
We have a scrutiny committee already.
No, appellate authority?
Appellate authority is the collector, Your Lordship.
Okay. Your notification is there. That showing the collector would be if the order is passed by the Tahsildar. But it says that by notification.
Your Lordship. That has been done, Your Lordship. I don't have that notification presently, but it is there.
Try to find out it.
Your Lordship. In the present case, challenging the rejection.
Yes.
The respondent had approached the learned single judge. The rejection order, if your lordship has the writ petition. Writ petition annexure 3 is the rejection order.
Annexure 3.
Annexure 3, page 28 of the writ petition.
Yes.
And may I take your lordships to page 30.
How many writ petitions you have filed?
4 minutes.
4 only.
4. On different the rejections, different reasons.
But page 30 records at the second paragraph that the certificate issued in favor of the father of the respondent has been cancelled, and that cancellation has not been set aside till date.
Even not challenged.
Yes.
That has been challenged. There is pending adjudication.
No. It was disposed of.
But that has not been set aside.
What is the result of this?
The result, the final order of the Honorable Single Judge in that case said that since time has elapsed, it will be adjudicated in course of time, without saying on merit of the cancellation.
So have you challenged that?
Yes. He has challenged it.
No writ appeal is pending.
No writ appeal.
Then if that
WPC 15 of 2008.
WPC has been disposed of, so have you challenged that order?
No,
That order stands.
the cancellation, the ground was taken by the London Tahsildar, and that was also adjudicated by Honorable Single Judge in the earlier writ petition, and the order dated 1st of December 2022 was taken into account, holding that since the Honorable Single Judge had held that no effect at all of the cancellation by elapsed of time, so much of time, so it will be decided, leaving the question of law open.
So it was not decided in
It was not decided on merit.
So on merit, it is still this order of cancellation still is valid in the eye of law. Because someone I observed that it will be open. Only the law is open.
Law is open.
Yeah, it is always open, whether I say or not. But on the merit or the finding of the Tahsildar who consent the certificate, it's still in force. When the father's status certificate has been cancelled, how the son can claim? On the simple ground, he can reject this judgment.
But I accept for a moment the father's caste certificate is sub judice. Let me accept my terms.
It was disposed
now. It was disposed of. The grandfather was given certificate. My cousin was given certificate. My mother has been given certificate.
Immediate father's certificate on verification has been cancelled. That's why not challenged. There was no exercise of verification. Yes. How those other cases can be compared for purpose of determination of the caste status of the present respondent. It cannot be.
That order here
The cancellation order, you know.
of his father's.
That is not it. That is not.
But this is, I think, is an admitted position.
Your Lordship.
He's himself admitting.
And in the order that you have challenged, your father's name is Ashok Chandra.
Yes, Ashok Chandra.
It has been reflected in the order of the Tahsildar.
Yes. And the earlier round, the Honorable Single Judge has said this cannot be a ground to reject the caste certificate. And that order has not been challenged by the state.
Which cannot be a ground?
Initially, when the first round of litigation, when I applied my caste certificate, Madam Tahsildar rejected my caste certificate on the ground, only on the ground that father's caste certificate was sub judice. Now that by the time the writ application was disposed of on 1st of December 2022, holding the adjudication will not be done now and leaving the course of law open. Now when the cancellation order was challenged before the Single Judge, the Honorable Single Judge held that the father's ground of cancellation of caste certificate cannot be a ground to reject the caste certificate of the petitioner. I mean, the son of the Ashok Chandra. And that order was challenged. Again, the Honorable Single Judge remanded that matter to Tahsildar, saying, you consider it afresh, or either issue the certificate or reject the caste certificate.
Yes.
Then once again, the supplied the reasons, the Tahsildar supplied the reasons in which is impugned in the writ petition. These grounds were taken.
Mr. Mishra, the Tahsildar rejected again.
Again rejected.
Yes.
Again rejected.
So because he had not given those reasons, that was remanded. Now he's given reasons and
reason
yes,
that was rejected.
Yes. So that was set aside and he was asked to give reasons and decide. He has rejected. So that the single judge has decided that they are challenging.
That they are now challenged. The Honorable Single Judge, all the grounds were taken, which is one, migration was taken. Second ground was the record of rights, revenue records. It was in the earlier settlement. Before the state formation of the Orissa state as a province, as a state, that in that record of the whole point is the revenue record prepared by ex-state of Patna, that is 1935. The caste entry of the grandfather of the great-grandfather of the petitioner was Telangana. Now, subsequently, my grandfather, petitioner's grandfather, he challenged in a OSS revision before the settlement commissioner, highest revenue authority. And that order, the caste certificate was changed from Telangana to Kondagora on the basis of various materials from record. That settlement revision order, passed way back in 2002, that was challenged in a writ petition before the division bench of this Honorable Court. And the revisional order was confirmed. Thereafter, the very same Tahsildar himself had passed the order correcting the revenue records. Not only that, the father's caste, the revenue record also was changed, was again given as Kondadora. So revenue record wise, my caste was recorded as Kondadora. Now the Honorable Single Judge held in terms of section 13(3) of the proviso, the lateral entry, subsequent entry will prevail unless and until otherwise evidence comes in to demolish that presumption. So the whole entire basis of the rejection is revenue entry in the revenue records. Now the two documents, I relied upon my grandfather's certificate, my mother's certificate, record of right published in favor of my father, reflecting the caste entry, Kondadora.
But that was after verification was cancelled.
No, that was never cancelled. That was subsequent event.
No. When you applied your father caste certificate was there. When you applied, present respondent to the writ petitioner.
No, that was in the writ application was already disposed of.
So your his father's the caste certificate remained and the cancellation order remained.
My submission is that as on the date of my application for caste certificate, the father's record of right ROR was published by the very same Tahsildar with the caste entry Kondadora.
Okay.
And another document which I published, I relied upon, is the circular of the state government of Orissa, which was challenged by another writ petitioner, and that was affirmed. And the state government there supported me by filing counter affidavit, and that was part of the record in before the Honorable Single Judge. And circular says the Telenga word Telenga is a colloquial term and is an honorific title. The Honorable Single Judge has written it, and it cannot be utilized as a to reject my caste.
It cannot be a caste.
It cannot be a caste. It cannot be a caste.
But what is the caste again? That is the question.
That is my the SCI which report which was verified.
No, because what I was telling, I have also done some cases 20 years back. A cousin is granted a certificate, the other may not be granted, and some that have been granted.
I want to see the presidential order regarding the state of Orissa. Which of the communities has been recognized? Because in the presidential order, the community or the sub-communities or the subgroups name is specifically mentioned for purpose of the issue and the status certificate. And that is the foundation of everything.
Yes. You're right.
1950 constitution order.
You're right.
Right. You just bring that.
I will bring that.
We are fixing on next Monday. Keeping this on there.
Yes.
Let us see.
Right.
One thing is there, Justice Ratho was pointing out there's a lot of inconsistencies during the exercise takes place. Suppose the cousin is given this caste certificate, the person who is another person out of the same broader family is denied.
Because some villages complain, then they take some documents, make some inquiry and cancel. But the thing is, his cousin might be having because common ancestor, but another one may not grant.
No, this issue can be distinguished because unless the verification exercise is done
properly.
That is the moment the verification exercise is done and something irregular or the unacceptable things has been accepted in the earlier certificate, that can be removed. There is no issue in that.
Yes, some orders are also like that. That's
so because here is an issue, first of all, that as I understand from Mr. Mistra's submission, that in the revenue record may not be by the same Tahsildar, but it has been recorded, the Kondadora, which is the recognized.
There is an issue there.
the original 1935 records showed that the caste is Telenga, and Telenga is a recognized caste under the SEBC category.
Oh, it is a caste.
It is a caste under the SEBC category.
Okay.
Now,
SEBC is the other record community.
Your Lordship, OBC. Now, in 2002, the grandfather applies for correction of the ROR on the basis of the caste certificates which were erroneously issued to them. And on that basis,
No, erroneously issued in the sense, have they been subsequently cancelled?
those have not been cancelled.
Then how can you say erroneously issued?
But it is of after verification, thereafter it has been cancelled. At least the father has been cancelled. My lord, the correction in the ROR actually not.
In fact, there are some cases, what you are saying, not cancelled. The High Court has said that since they have availed the benefit, so that will not be withdrawn.
Yes.
It has not upheld that this is a scheduled caste or anything. So that's, those sort of orders are also there.
Your Lordship is right. But the correction in the ROR is made on the basis of caste certificates which are now under challenge.
Okay.
Do those very things.
Did they like the caste or then you?
Now, this creates a lot of problems. Suppose in the revenue records, the stating your caste on the basis of the certificate, and the very certificate puts under the verification and found that was not properly issued.
Yes.
Then the ROR cannot be treated as the evidence for determining your caste.
Correct, madam. Correct, madam. Here in my case, the grandfather which succeeded in the revision, changing the caste, he relied upon various judgments of the civil courts, declaring the caste, produced various cell deeds, which unflinchingly say that caste is Kondagora. Now what my friend is saying, those things that is Telenga is a caste and my caste is Telenga instead of Kondagora. Those facts were entered into by the SCFTI, under the SSC Development Department, and in 2011, a clarification circular came in, basing upon the ethnological, sociological, and anthropological studies in a comparative view taken from the the Rayagada and Koraput district and Kondagora people living in Western Orissa. And the ultimate conclusion is that I will show my note for a moment if I read it.
Again, that area also you have to check. Koraput, Rayagada may be different, this area may be different.
That study was made, my lord. Ethnological, anthropological survey was made by the institute.
But that survey also finally says that Dora is an honorific title.
No,
it is a surname. Dora consists of both non-tribals and Kondagora. So there has to be some evidence produced by the respondent that he belongs to the Kondagora.
Traditions will not change. Death rights will not change.
No, but it is Dora is a title. So just because it is a title, it can't become a scheduled tribe. Scheduled caste.
That is not
Tribe.
The burden of
when you say before this court that under the title Dora, both the ST and the other non-ST communities are also recognized. And it is the honorary title.
Honorific title.
So under this title Dora, there can be also the ST person.
Definitely, Your Lord.
So you're saying that it is the duty of the petitioner to produce the record to show that he belongs to this sub-tribe, this Dora or Kondagora. So he has not filed any document to that extent.
He has only relied upon the settlement, the ROR correction order.
That is a record.
But that in itself, Your Lordship, is under question because that is based on that correction is based on the older certificates
which is now under challenge.
Which is now under challenge.
Again, he is coming with again wrong submission. The caste entries way back on 1935 ROR.
No, that is Telenga.
That is Telenga. Now, subsequent RORs were published with Kondagora. Now, my friend is saying.
When is the revision order? Have you annexed the revision order?
2002, madam.
Where at annexure?
Annexure 10, page 51.
Yes, 51.
In the writ petition?
Yes, of the writ petition.
All right. Let us see that order.
Yes, 52 is the relevant part would be. It is 50B revision.
Yes. It is in 2002.
2002. And this order was never challenged. challenged by by another person before this honorable court, and that was set at rest. Dismiss the confirm this order.
No, confirm this order on merit or because of maintainability. Because sometimes this court doesn't interfere when a private party challenges those orders.
Private party challenged, but state has never challenged it.
No, so that was on maintainability or on merit? Was it on merit or maintainability?
Merit as well as.
Where is that order?
That order I have not annexed, but I have said in my writ petition at paragraph.
Sometimes the state doesn't carry or the villages carry.
Yes, madam. Para 16, towards last, WPC number 11494 of 2003. Wherein challenge was made to the order dated 21/9/2002, passed in revision case number 297 of 2002. This honorable, after hearing the party judgment, had been pleased to dismiss the same by judgment dated 24/7/2006. And this order was also never challenged by the state. Neither revisional order nor the.
So your only evidence is the ROR.
And
others you have narrated because there is no documentary basis.
Documentary evidence, my grandfather's certificate, my mother's certificate, my cousin's certificate belonging to other branch. My great grandfather had 2 branches. The other branch has also been granted certificate.
Yes.
And I also relied upon the caste certificate of this neighboring Tahsil, where also Tahsildar has granted certificate. Even though the caste record of right, they are said it is Telangana.
Mr. Mishra, that annexure 10 which you are referring to, it says in the civil suit, it was said that there is no caste called Telengi. And the evidence of the plaintiffs is satisfactory that they are Kondhatora by caste, which is a set of Adivasi people. So that Telengi is Telengi or Telenga?
Telenga caste.
Telenga,
you are saying caste is there and the civil court has said there is no caste as Telengi.
It is there now, Your Lordship. If Your Lordship has this book.
No, there is no caste like, I think Telengi, bhul print Telengi, they are saying there is no caste called Telengi. Just look at that order,
Telengi.
page 53. Order doesn't say Telenga, it says Telengi.
That may be a typographical mistake because everywhere it is coming as Telenga.
No.
And the original record of rights, it says Telenga. The original record of right I have annexed to my writ
It
appeal.
must be Telenga. Then again it says, though there is no caste called Telenga, but now you say there is a caste called Telenga SCBC.
That is at page 188 of the SCST manual, Your Lordship.
This printing mistake again, Telenga.
Page?
This manual, if Your Lordship has, page 170 is the central list of OBC starts.
And say research
in
officer.
the petition itself I have annexed it.
Research officer of director SCST says there is no caste called Telenga. It is a linguistic term. Again, we have to see these typing mistakes, whether it is actually a typing mistake or they are referring to some other term. If you look at the end of paragraph 3, it says Teleng.
Your Lordship.
It's Telenga or Teleng?
It has to be Telenga because the original record of right says Telenga.
No, the report of the research officer. Because change in spelling also matters because there have been a lot of claims basing on slight change in spelling of the caste, claiming that we belong to that same caste.
But I have annexed the Gazette of India central list.
Other relevant documents.
In the central list, it's at serial number 169 is Telenga.
Telenga.
Serial number 169 at page 188 of the book.
Wrongly missed.
You may kindly look to the Gazette which are annexed in the writ petition. That will clear the confusion.
2002.
Where is that page?
Gazette notification at page 13 of the additional affidavit. If you see gets it rejoinder affidavit. Rejoinder affidavit page 13.
Again, there is Kondhatora and again Kundadora.
Your Lordship.
In fact, the word Kunda means stone, here hill. And Dora means the chief, the literal translation of that term. The gazette notification also got it at page 15.
So this revision order says Kondha Dora.
Kondha Dora.
But they are being given caste certificates as Konda Dora. So there's a difference between both.
Konda Dora is what is scheduled, Your Lordship. Page 46 is the central cost, the constitutional order, which
Then the revision order is Kondha Dora.
Your Lordship. Kondha Dora.
Is filing the application file because they have not scanned the rejoinder.
Wait, it's an email.
Application reports are there. Just find out whether the rejoinder is there or not.
Petition, all right. Oh, they have not scanned?
But at the top right hand corner, I have pencil mark.
Yes.
Gender in the restriction.
What is this Kandradora is there in that?
The list. The state presidential order.
The presidential order is at page 46 of the book.
Why does it?
Your Lordship may have.
The number five, no filing. A boiled name.
What is the entry number?
37.
Kandradora.
काय होय आम्हाला कोर्टर वर कोर्टर नाही.
What is your submission in respect of the observation made by the Tahsildar in the impugned order in respect of the further caste tribe certificate?
Father's caste certificate. Father's caste certificate, in the earlier round, the father's caste certificate cancellation was challenged before the Honorable Court and stay was granted. Thereafter, ultimately the time after the elapse of so much of time, the writ application was disposed of, holding that because of the lapse of time, need no adjudication, leaving the question of law left open. Now, the very same ground of rejection was taken into account in the earlier rejection order by the Honorable Single Judge, and he said that the father's cancellation cannot be a ground for denying the son a caste certificate, especially when the grandfather was given certificate, mother has been given certificate, and the cousin in the other branch had also been granted certificate, caste certificate.
Cancellation or because it was sub judice?
Because the earlier round of the father's caste certificate cancellation was sub judice.
Yes, sub judice, not cancellation. So that is why it was remanded.
What is the Tahsildar's order? It is in the writ petition?
It's in the writ petition, Your Lordship. Annexure 3.
This book, which page, Mr. Behra?
Page 46 of my book. This is that's
Serial?
37.
37. Konda Dora. That says Kondha Dora.
Only you argue on that point. Because government challenge is that since the father certificate was cancelled on verification and it was not been judicially intervened, it is still on record in the cancellation of the order. Even the father is not recognized as a scheduled tribe. How the son can be recognized as a scheduled tribe? Let us focus on this point first, how to overcome this point. Because your submission has been very descriptively recorded by the Tahsildar. I'm really amazed the way the order has been passed. It shows his maturity. I'm coming across such order for the first time in my life, so well written an order. You read this your submission recorded after the next paragraph. After recording your submission in that order, you just come to the next paragraph, which starts an ongoing through the official records. It is found that so father certificate was cancelled. Only issue that will trouble this court is that when the father certificate is cancelled and there sought to be a judicial intervention, but no intervention has been extended to. How on the face of such a record, a Tahsildar can issue a tribe certificate in favor of the son?
I have a right to get a caste certificate independent of my father's. For the mandate of law is that the Tahsildar has to make sociological, anthropological, and ethnological study of that area, that my caste.
No, now Mr. that it is a right.
It is a right.
It is a right of not very individual right. It is a right of a community.
Right of a community.
You are enjoying that right of the community for as individual purposes. That is the purpose of issuing the certificate. Try to understand me. When the father has been already adjudged not to belong to a tribal, the community or the tribe, and this order was challenged by the father, only when a single judge says the issue of law will remain open. It will remain open for the world, not only between the parties.
Between interstate.
Right.
Yes.
Not interstate. It is remain for the parties, whether the certain community can be designated as a tribe or not. This is also not beyond the community also it extends this thing. But here that in view of this, how can we say that we have to interfere with the order by which the tribe certificate of the father was cancelled? Because you are acknowledging that he is my father.
Yes.
It cannot happen. The father is a non-tribe and son can be designated as the tribe. That cannot happen.
The grandfather's caste certificate was never challenged.
That is forget about all these certificates, those who are not under the verification exercise.
Yes.
When a verification exercise was taken, it was found the father certificate was not proper. It was improperly issued. They have cancelled it, and the father challenged that cancellation order, but court did not interfere. Court said the question will remain open, for. But as a matter of fact, it remains the father caste certificate is cancelled, and it is still in force. The order of cancellation. How on the teeth of that fact, any court can hold? No, we are declaring the son as a tribe.
For a moment, my lord, I assume
just because you are a seasoned professional here in this court, you know that when the similar, that is ultimately the community status that is being verified. Right. And son also say that he has been born through the father.
Yes.
And that my father was also, my grandfather also, that he was taking the lineage, as you were saying, the anthropological survey and other thing, as Madhuri Pati was quite categorically cataloged the thing. And that is good law as of today. So when the father certificate is cancelled and cancellation order was not judicially intervened, it means that order remain in force. Whether on the teeth of that fact, any court can say, no, give the caste certificate to the son.
That is why my submission was, when the earlier round of litigation, the sub judice ground was taken into account by the London Tahsildar, This aspect was taken into account thoroughly by Plan and Single Judge in the earlier writ petition. Definite order was passed by that.
What is that order?
That order. That order.
No, that order is not part of these your annexures.
No, yes, I have said in my writ petition itself. I have said.
No, said I look to see the order.
My brief is it. Sorry.
You have annexed that order.
I have quoted that order, and the Honorable Single Judge has referred to it.
No, whether have you annexed with your writ petition?
Yes.
We are not finding it.
That is at page 23. It begins.
Page 23.
Yes, 8962. WPC 8962 of 23. Yes, in the earlier round.
21/4/2023.
This is a father's order.
No.
I am asking about this order filed by the learning secretary earlier today, father's writ petition.
No, that petition I have not. 15 of 2008.
Mr. Behra, that is the issue actually, that there no others. First of all, no fresh inquiry is required according to me, number one, because the status certificate has been cancelled. And that was never challenged in substantially, because the London Single Judge also passed that we are not interfering, but this question may remain open for all. But because of the existence of the cancellation order, how the son can apply for their status? You are absolutely right. He has individual right to apply for this caste certificate. Nobody can dispute that also. He has applied, nobody resisted that you cannot apply. But ultimately, when the verification was made, this order is a very important document, because it was earlier a verification was done and the caste certificate of the father was cancelled, that was challenged, but the court did not intervene. Whatever the observation is made, the fact remains, the order remained at force. So whether Mr. Mishra, that you just say, since think, I mean, in that perspective, that whether on the teeth of that fact, the son can get this certificate.
I will make a research on that.
I'll make it come on. We are making it parted.
Mr. Mishra, the order is that since the term of the chairman of the Panchayat Samiti is over, so it need not be attended at this moment. However, question will be decided. So exactly, since it has served its purpose.
Well, because I'm really, if that is the order, I'm really failed to understand how a change of the Panchayat Samiti can just debar from reviewing the order or research this. Yes.
Because the meaning is that all right, chairman, that term is over, but you cannot use that caste certificate again.
He was the Panchayat chairman, Panchayat Samiti.
The earlier round. Now I'm mothering the Panchayat Samiti chairman.
No, because I understand, because maybe his status in that, because he returned from a reserve constituency. So therefore, since that term was over, he says it is merely academic exercise.
Is mother enjoying?
It is not.
Mother not present is the chairman.
Chairman because of reservation or otherwise? That is not the challenge. Oh, mother is different. She might have got the caste certificate. Okay.
The mother may have the separate.
Yeah, she might have come another.
No, mother is also Kondagora. I have understood
difficulty in the Kondagora. Maybe. Try to understand that mother is real Kondagora. Whether you are real, that is the question. Got my point?
Yes.
Otherwise, maybe that the reservation was for the women. You don't know. The mother as a woman can contest the women reserved seats. But here says, but it was not, but you should have carried an appeal against this order, but you have not done it.
But that was for the limited purpose of maintaining the seat. So you have given up.
I think that is creating a real difficulty for.
In fact, the case I had done was also like that. He wanted at least.
You appeared
at the time of hearing, the first question was whether the term.
Exactly. I'm telling you, I myself had argued a case. He asked for,
Very next order.
First of all,
asked for admission on that ground.
all humility to all, the challenge was the determination of your tribe. And Tahsildar says you do not belong to that tribe that you claim to belong. Right? That was the issue, and your status certificate was cancelled. But here says since it has become irrelevant because the term is over.
Technical
That cannot be the issue. Because the certificate is not only used only for this contesting an election, there are so many other areas also the certificate will be required. But you left there, you did not carry out the challenge for the.
One father, again his children will make use of that. Unless his certificate is valid, how will children take advantage of that?
What happens, I am telling you, Mr. Behra may not know because he has not practiced in that level. He's always in the Supreme Court, in the High Court. Doesn't know that whether we're going to the Tahsildar, even when he is satisfied with the father's certificate, he will not make any further inquiry. Just based on the father's tribe certificate, he will grant the tribe certificate to the children. He will only inquire into whether the applicant is really the child of that father. Because other is useless. Once he has carried out the community determination through anthropological materials and other things, and the family lineages. So that is creating a real.
Yes, I got your lordship.
So that is the issue.
Your lordship.
They heard Mr. B. Mistral on a council. No, heard Mr. Behra on council appearing for the Behra for the appellant, and also Mr. Digamba Mistral and council appearing for the here for the sole opposition, sole respondent. So the question that is paramount in this appeal is that when the father of the respondent, namely Ashok Chandra Dora, was the status of the father of the opponent, namely Ashok Chandra Dora, was verified and found by the Tahsildar that he doesn't belong to the Khanda Gora, rather he belongs to Talinga, which caste also belongs to the other backward communities. The tribal status certificate, tribe status certificate was cancelled in the year 2003. The said order of cancellation was challenged before the collector Bolangir by the appeal number 03 of 2003. The collector had reversed that order of cancellation of the status certificate and remanded the matter for reconsideration. So after going through at the time of the reconsideration, the Tahsildar cancelled the caste certificate by his order dated 22/12/2007. Mr. Mistral on it council has pointed out that said cancellation order was challenged in WPC number 15 of 2008 in this court. So by the order dated 1/12/2022, the writ petition was disposed of, having observed that the question remains academic and need not be attended at this moment. However, the question involved therein, if raised in future, will be decided in accordance with the law. The said order dated 1/12/2022 was not challenged, and by efflux of time, it reached its finality. Stop. Now, on the basis of the order of cancellation dated 2007, whether, no, on the face also, not on the face of the cancellation order dated 22/12/2007, the respondent can claim the status certificate for being a member, status certificate. Stop. It has been observed by the Tahsildar in the impugned order, in the order dated 6/5/2023, which has been challenged in the writ petition being WPC number 16069 of 2023, concerned with this writ appeal, in this intercourt appeal. That before correction of the ROR in Khata number 23, and RTs are Ganeshwara Dora, Dhananjay Dora, and Dharmaraj Dora, Jagabandhu Dora, son of Parakhito Dora. The caste has been recorded as Telinga. Again, went through the revenue miss case number 310/2002, Nityananda Bhai versus Ashok Chandra Dora. It has been recorded in the case record that OP has admitted that their forefathers were migrated from the Telangana to Orissa, and because of their migration, they are called as Telinga instead of Konda Dora. Stop. It has been also observed as follows. As the forefathers of Sri Ashok Chandra Dora are migrated from Telangana state, the then Tahsildar has ordered for cancellation of the caste certificate number 244 of 1988 on the basis of the circular published by the State of Affairs, Government of India / Bharat Sarkar, Ministry of Home Affairs / Griha Mantralaya, by later number 35/1/72-RU within first bracket Act Roman 5 close the bracket dated the April 1975, Boishakha 1897, regarding issue of SC/ST certificate, in which clause 2 within bracket 2, wherein it has been clarified that as a person migrated from one state to another, he can claim to belong to a scheduled caste or scheduled tribe in relation to the state to which he originally belonged and not in respect of the state to which he has migrated. Stop unquote. It has been also observed that the Kondagora is recognized as scheduled tribe in the state of Orissa in view of the Presidential Order 1950. Stop. Therefore, that observation of the Tahsildar is completely, as quoted, is completely irrelevant in the present context. Stop. As the respondent has been claiming his status as a member of the community called Kondagora, which is already recognized as the scheduled tribe. Stop. Mr. Learned Counsel has submitted that by virtue of the settlement revision case number 297 of 2002, the records of right, as was standing in the name of the grandfather of this respondent, has been changed from quote unquote Telinga to Kondagora. Stop. And the said entry still continues in the revenue records. Stop. There is also no dispute that the revenue records is treated as a reliable evidence for purpose of determining the status of a person. Stop. Therefore, the only issue that is to be answered by this court, whether on the face of the cancellation order, whether on the face of the order cancelling the status of the Ashok Dora, the father of the respondent can claim the said status as on verification it was found Ashok Dora doesn't belong to Konda Gora community, and his challenge by filing the writ petition number 15 of 26 did not bring any interference, did not bring any change in the circumstances. Then the cancellation order remained intact, so far it's intact. Therefore, it has force stop. Even though in para 3 of the order dated 1/12/2022, it has been observed that the question involved therein, if raised in future, will be decided in accordance with law. Stop. This is a wide liberty granted to the petitioner of WPC number 15 of 28. So, but the fact remains, thereafter, the cancellation of the status certificate of the father of the respondents who were never challenged.
I will file a writ appeal, carry it an appeal.
No, that you filed as of now. Stop. Stop. In view of this, let the matter be listed on 21st of September 2023, when we'll allow the counsel for the parties to argue only on the point that on the face of the cancellation order of the status certificate of the petitioner, the respondent's father, the respondent can claim the same status or not. A copy of this order is supplied to the counsel for the parties.
Right.
You keep it. We are keeping it on record.
Yes, yes.
21st September.
I know this argument before taking the next matter, and item number 1, the lordship had fixed on. I have some personal difficulty. I have requested Manit Counsel Mr. Mukherjee is agreed for 13th, subject to lordship's acceptance. It can be changed to 13th. Item number 1.
Well, the learned single judge is granted 6 weeks time to comply with the order. That's by 21st September, that 6 weeks will have lapsed.
No, this 13th we are taking on 13th September.
13th September,
Yeah, we fixed earlier on 11th September. Now it is being changed to 13th September.
The item 2.
No, the one.
21st.
Past matter.
Oh, when it was given?
21st September, Your Lordship. But by the time 6 weeks will have lapsed.
So where is Mr. Mishra? Can it be? We're fixing it on 11th of September. 11th of September. All right.
Item number 3. May I please, Your Lordship?
Yes.
This is public interest litigation in violation of the OGLS Act, Section 3. The Gochar land has been used for other purpose.
Yes.
I'm relying on Section 3 of the OGLS Act, where it has been provided that no government land recorded at Gochar shall be reserved for any purpose mentioned in Clause A or settled under Clause A without being de-reserved in accordance with the provisions contained under Section 3A. So Section 3A provides the procedure for de-reservation and how the land will be de-reserved. The Rule 1983 provides, Your Lordship,
83.
Act is of 1962.
Rule is of 1983.
Rule is of 1983.
What it provides?
In the first commission is the Act, Section 3 of the Act.
Section 3 of the Act that can be de-reserved by the government.
Yes. And the rule 83, your lordship will find page 34 of that book. Deed reservation principle.
Yes. What is the rule?
That is Odisha Government Land Settlement Rules 1983.
You are referring to manner of settlement of the government land? 5? Rule 5.
Rule 4, man.
Okay, you are referring to rule.
Deed reservation.
Yeah, de-reservation principles.
Yes.
Like,
any land which has been reserved under clause A of section 1 of section 3 or recorded as gochara may be reserved by any officer not below the rank of collector authorized by the state government in that they are. In making such deed reservation, the following procedures shall be followed. The procedures have been laid down there. The first procedure that notice, but here there was neither there was any notice, nor there was any deliberation or deliberation stating that land has been used for the purpose of constructing a grammar khada. That construction.
I'll take instance. His allegation is that we are using this gochara land for grammar khada
his allegation is much serious than what you have perceived.
No, it was a serious allegation.
Your own officer is violating the laws.
No, your lordship is correct. We have to take instruction. What is the correct status? Because
so when we fix the matter,
10 days after.
There, in the meantime, on 28th of July, this matter was there.
12 can be fixed 12 September.
Your lordship can. I have got the photograph of it.
Counter affidavit.
No, these are all the just a short counter affidavit will be filed.
Well,
okay. That is. But Mr. Dipti Ranjan Mahapatra, Land Council, appearing for the petitioner. The allegations made in this public interest litigation are very serious in nature. It has been stated that it has become a practice by the government official to occupy and construct government offices or road over the gochar land, over the land classified as gochar, in complete violation of Section 3A of the Orissa Government Land Settlement Act 1962. Section 3A is related to power to de-reserve land, and it provides that the government may, by notification in the official gazette in italics, authorized any officer, not below the rank of a collector, to de-reserve any land which has been reserved under clause A of section 3 or any government land recorded as gochar or any portion thereof. Then it has been further provided that any any officer authorized under subsection 1 shall, subject to such condition and limitation as may be prescribed, have power to de-reserve any land referred to in that subsection or any portion thereof, if such officer is satisfied, such land or portion thereof, as the case may be, small a, just go down below, A is no longer required for purpose for which it was reserved, or small b within bracket, can no longer serve the purpose for which it was reserved, or C is in excess of the reasonable requirement for the purpose for which it was reserved. So, provided that after semicolon, that the officers so authorized shall, in assessing the reasonable requirement for the purpose of gochar, follow the prescribed principle laying down the extent of gochar land to be set apart for use by the community. According to Mr. Mahapatra, that Rule 4 of Orissa Government Land Settlement Rules 1983 has clearly laid down the de-reservation principles. So the officer in the present case has given a complete go-by of these provisions of the rule and started a construction of Gramakhara stop. Issue notice returnable on 12th of September 2023 since Mr. D.K. Mohanty, Learned Additional Government Advocate
225.
appears for opposite parties number 225. No formal notice is called for in respect of those respondents, but the petitioner shall take steps for service of notice on the opposite party number 1 by registered post with AD by tomorrow. Stop. It is expected that the principal opposite parties number 225 shall file their affidavit by the next date.
Can it be on 15th or can it be on 15th or 15th?
The 15th cannot be 14th, can be 14th.
14th, obliged.
14th. A copy of this order be supplied to Mr. D.K. Mohanty and Council for onward transmission.
Yes.
May I pray your lordship and direct and no further steps be taken in the meantime?
I think
or start up your lordship and direct as on today.
This is only your lordship may say this is only a Gramakhara, there is no construction. So it is for the benefit.
All right, let him construct. We can also direct.
Yes, your lordship can direct.
Just for a second.
In all these cases, your lordship is directing that if ultimately it is.
That what we it is. We believe you. He is also not disputing that there is no construction. If we find this grossly illegal, we'll direct to remove the
yes,
house.
that can be.
There's no issue in that. Because in the meanwhile, we stop, the government will further lose because the contractor will immediately ask for the money from the government. Right? That we should not do. All right.
Item number 4.
And Mr. Mohanty, you just tell them not to proceed with the further construction.
Now, let me see whether it is actually de-reserved or whether it is completely on.
You produce the records also.
Yes.
Yes.
Sorry, my lord, item 43, your lordship.
Call the matter. Just one matter will take up.
My lord, this is a matter, my lord, regarding.
Just wait. Another matter is fixed on 12. We'll take.
My lord.
Yes. Just 14 hours about the first. Who is appearing with the item number 17?
17 I am there.
All right.
Was a covered matter, I believe my.
Just wait, it's a short matter.
My lord.
Who is appearing with the state that covered matter?
Yes, same type of copy. Impugned order is.
Mukherjee, Senate Council, listed by Mr. R.K.D. Das, that council for the appellant, and Mr. Devakant Mohanty, the regional government advocate, appearing for the respondents. First in I number 429, I think it is a 92.
292.
4292 of 2020 limitation. That was not. This is an application for section 5 of the limitation for condonation of delay. Huge delay. Mr. Mohanty, it is 1,897 days. Because in the other order, since
that is also, that was delay in that case also.
1897 days in filing the a court appeal from the order dated 4th April 2018, delivered in WPC number 3456 of 2018 by the single judge. Mr. D.K. Mohanty, Mr. Mohanty, an Indian government advocate, has clearly submitted that the state respondents will not oppose the prayer, or state opposite parties will not oppose the prayer for condonation of delay, as in the similar circumstances, this court has granted the relief by relief clarifying that ASO would not preclude the government from proceeding under Section 3B of the OGLS Act. Accordingly, the delay is condoned in WA number 161 February 2023. So this appeal is directed, as stated earlier, against the order dated 4th April 2018, passed by the London Single Judge in WPC number 3456 of 2014. Stop. By the said order, the writ petition has been dismissed as not maintainable on the ground that appellate has an alternative remedy of filing a revision under Orissa Survey and Settlement Act. Stop. At the time, it has been stated by Mr. Mukherjee and his senior counsel appearing to the appellant that at the time the impugned order was passed, the judgment of this court dated 2nd January 2023 in WPC number 1608 of 2014, titled as Narottam Ratho versus State of Orissa, 2023 SCC Online ORI 153, had not been pronounced. So, that judgment answered the question in favor of the present appellant that the Eastern Settlement Officer under the OSS Act could not have so moto at the stage of considering a request for correction of the record of rights, enter the name of the government. The court is clarified has clarified in the said judgment that setting aside the order of the ASO would not preclude the government from proceeding under Section 3B of the OGLS Act. Following the judgment in Narottam Das versus State of Odisha, this court set aside the impugned order in WA 131 of 2023 within bracket, Mrs. Manjulata Jena versus State of Orissa and others. In the similar circumstances, and directed that appellant's name will be entered in the ROR as prayed for, while at the same time reserving the liberty of the government to proceed in accordance with the law under Section 3B of the OGLS Act. Mr. Mukherjee has submitted that the safe decision of this court squarely covers the present controversy, to which Mr. D.K. Mohanty did not raise any objection, and he has fairly submitted that the above decision squarely covers the challenge raised in this present controversy. Having read the proposition of law as settled in the order dated 11/4/2023, passed in WA number 131 of 2023, we allow this appeal by setting aside the order dated 4 April 2018 as delivered by the learned single judge in WPC number 1456 of 2014, and direct the authorities to record the suit plot in favor of the appellant in terms of the. You are the part of the bench in that case?
Yes, I was also part.
In terms of the judgment?
No, in that, no, I was not part.
All right. Records. The petitioner.
In terms of the judgment passed in Narottam Ratho case.
Where you have described the land.
Your Lordship, like a copy, want a copy of that judgment in Narottam Ratho?
No, Narottam is in our hand. In your plaint, where have you stated the description of the land?
Description of the land, yes.
In terms of the land as described, in terms of the land comprised in plot number 1958/3172, Khata number 621/64, having area of 1.000 decimal under Moja, under other Rua, Hal Khata number 5, corresponding Hal Khata number 554, Hal plot number 4295, measuring hectare 0.4047 hectare, village Andharua, PS Chandak, district Khurda. Stop. So this stop, while giving the stop, we make it absolutely clear that they reserve the liberty of the state or the revenue authorities to proceed in accordance with the law under Section 3B of the OGLS Act, if they are so willing to. If they think so. All right. In terms of the above, this appeal is disposed of. There shall be no orders to cast.
Item 43. Well, so in this case, my lord, I may be pardoned, my lord. In this case, I am appearing for the respondent. My lord, I am not well, my lord. I press hot adjournment, my lord, because of it's my election petition, which is yes, my lord. So that is my urgency, my lord. I have also disclosed my health issue to my lord.
Wait. Can it be done on 5th?
Any date, your lordship.
So we fixed on 5th.
My lord, I oblige your lordship.
Can it be fixed on 5th?
Your lordship may grant us liberty to mention it so that
just finding out whether the slot for 2 p.m. is available.
Yes, no.
We make it on 12:30.
Oblige.
At the request of Mr. You are Mr. Das.
Panda, my lord. M.K. Panda.
MK.
Responded by.
You have appeared recently?
No, my lord, earlier.
It is 43 now?
43, my.
Is it equal to Mr. MK Pandal and counsel appearing for the sole respondent that the matter is listed on 5th September 2023 at 12:30 p.m. Mr. D. Mukherjee and senior counsel along with Mr. RATHO and counsel is appeared for the appellant.
Interim order to continue.
Interim orders passed earlier shall continue till the next day.
My lord, that I may pardon that item number 3, you also directed issuance of notice to opposite party number 1. Since opposite party number 1 is the annual has been over, the lawsuit grant me liberty to a copy of the
Mr. Pari can appear in a both.
yes. I have annual had been over.
Ministry of Government of India.
Yes.
Then we can.
Ministry of it is an animal, this welfare board.
Annual husbandry board.
Board is not a part of the
Government of India. Not the most.
That is take the notice.
Okay.
They are not the main party. Issue is something.
Yes.
This is a formal party already.
Why he has implemented opposite party number 1, I don't know, because it is all between the Tahsildar and
You
district
administration. That I want to get them that opposite party number 1 be deleted. That would be the good approach for you. Anyway, send the letter.
Item 4. My lord, this is a covered matter, your lordship.
Item 4, the similar nature of cases may lordship make some other day.
Yes, your lordship is saying.
Thereafter, my lord has issued notice, we have filed the counter in some cases.
Your lordship, this is a covered, my lord. The decision, my lord is showing your lordship. This is your lordship. See, your lordship's contention is same. Your lordship ₹50 fine, my lord, has already been set aside by this court and already set aside by the Chennai High Court. Both the cases, your lordship, this honorable courts also set aside ₹50 additional fees, my lord. Your lordship, we are the poor, my lord, the lorry owners, my lord. Fitness has been already been stopped, my lord, due to ₹50 fine, additional fees.
Not a issue of 50 or 5 rupees. The issue is that the government notification has been quashed by this court.
This court.
In some cases. In some cases, I also passed some different orders. And in some cases, it is pending for education, we have filed the counter. So what I am praying, my lord, all the cases we take together and it will come for 1 day for hearing.
You give all the case number.
My lord, I will do that. Very small things. Your lordship,
We understand. We might see a very short date.
Your lordship. Your lordship,
Can it be on 5th, Mr.
5th, my lord, 5th, your lordship.
5th. Can it be on 12th, my lord?
All right, 12th. But no further account. Because
in this matter, I had given a memo in the morning, my lord. That is 23387. That is a batch of cases.
Similar.
So all these cases, my lord.
In some cases.
This, Mr. Sarangi, one thing you do,
My lord.
you prepare a list during the recess
My lord.
and hand over to the court master.
My lord.
He will accordingly supply and all the matters will be listed on the same date.
My lord.
Just this will be the along with, huh? Just make it. Let the matter be listed. Let the matter.
Or lordship, 8th also. 8th Friday is open. 8th is open.
No, Friday division.
Friday, my lord.
Usually say.
Yes, my lord.
Yes, your lordship. It will be disposed of.
Not reaching, my lord.
And your lordship,
13, that is what I 30 they are fixing it.
my lord. Just my lord, your lordship.
Stated by Mr. P.K. Pari, Deputy Solicitor General of India, that some other analogous matters on the same challenge are pending in this court. All these matters are required to be taken together for avoiding different decision. So we find sufficient force in the submission, and for the reason we It is for that reason, it is the matter on 13th of September 2023 at 2. Can it be at 2? 2 p.m. Yes. At 2 p.m. Along with all other matters, a list of which will be granted will be supplied to this court by Mr. B.M. Serangal and counsel appearing for the petition within a short while.
Well, just now I'm giving them.
You take back this one of the day.
I'll give the number, my lord, to the person.
Tomorrow I have some matters also, my lord.
Let us give all the numbers today.
My lord, today I am giving.
And tomorrow those matters will not be listed in view of the hour order. That information will send there.
Title number 5.
Maybe. The villagers representation with regard to construction by rupees 428 over government land. My representation is under annexure 4 and same has been duly received by collector opinion number 2 under annexure 5 series postal receipt and annexure 6 series is the tracking department. Rupees 428 are constructing the government land, causing hardship to the villagers. Annexure 2 is the ROR showing the suit land in government land.
Mr. Mohanty,
Tahsildar may be directed to cause
due inquiry
on the basis of the representation which he has given.
Tahsildar opinion 3.
Marsaghai. And by giving opportunity of hearing to the so-called encroachers.
Heard Mr. Bhashya Mohanty.
Yes.
Land counsel appearing for the petitioner, also Mr. D.K. Mohanty, land counsel appearing for the state opposite parties. By means of this public interest litigation, the petitioner has alleged that the opposite parties number 4 to 8 have been illegally occupying the 4 to 8 illegally occupying the government land comprised in plot number 566 and 566/1459. Pertaining to Rakita Khata number 396 of Mauja, Sasini Pada, PS Patakura, District Kendrapada. Despite the representations filed by the petitioners on 17/7 to the collector of the Kendrapada, no actions to protect the government land has been taken by the opposite parties. Mr. Mohanty, the counsel for the petitioners, have stated that the responsible government officers are ignoring their duties to the government to public properties, and their inaction has become instrumental to illegal occupation over the government land. Stop. Mr. Mohanty, an additional government advocate appearing for the opposite parties, has submitted that the allegations cannot be accepted on the face of the representation. Inquiry is to be made, and thereafter the due action can be taken. Having regard to the statement made by Mr. Mohanty, an additional government advocate, we direct the Tahsildar
Marsaghai. District
Kendrapada. To
copy number 3.
Copy number 3 to cause inquiry into the allegation made in the representation dated 17/7/2023 and to take action against the encroachers in accordance with law. it is, we clarify that before taking any adverse action against the person who is illegally occupying the government land, they shall be given an opportunity of hearing. So, such representation shall be disposed of. Such inquiry shall be completed within a period of 6 weeks from the date of receipt of this order, which shall be filed by the petitioners to the Tahsildar present such within 7 days from today. As a measure of abundant caution, we direct the registry to furnish a free copy of this order to Mr. Mohantil and National Government Advocate. Forthwith, Mr. Varjin certified copy suggests. Next.
Item 6.
It's a public interest litigation. Unauthorized construction of a road over the government land, that is Kissamaj Gocher Melo. Annexure we have 1, your lordship have England Sarwar, annexure 2 and 3.
Same allegation, only Tahsildar is different. Here Patamundi Tahsildar under Kendrapara district.
Annexure 2.
The commercial number and the number will be the same. And heard Mr. Rajkumar Sutha.
Yes, R. Mohanty, Ranjit Mohanty.
Heard Mr. Ranjit Mohanty and Council, and this is the public litigation. Same thing. Here, the same 6 weeks.
Yes, 6 weeks.
And a representation is dated Annexure 3.
Annexure 3 at page.
All right, it will be within 6 weeks, inquiry will be completed. And action will be
And in
taken there.
case of Marsagai, it should be Patamundi, Tahsildar.
You take it for the person. Yes.
Item 7. Item 7, may I please? Is a application malleable for a direction to the opposite party's malleable for a criminal action against the private opposite party malleable for the recovery of a misappropriation amount malleable, which is as per the inquiry report malleable, which is annexed in Annexure 8 malleable.
Have you filed any complaint to the police?
That has been filed, my lordship.
Where is that complaint?
That report is not.
Unless you show the complaint, we will not pass any order. Because representation is immaterial. We want that you file a complaint because, according to you, a cognizable offense has come to your notice.
My lord, similar matter was dismissed by division bench of this honorable court earlier with the same allegations.
That has been dismissed. That I have not attached that documents, that findings that has not attached within the annexure malleable. For that it is I have no in this writ application that
you filed the complaint to the police.
I have already approached the police malleable. The inquiry already initiated malleable. I have I'm going through the page number malleable. The inquiry has initiated against that opposite party number 14 malleable.
Why is such record that you have filed a complaint?
Inquiry has been inquiry in Annexure 8 malleable. Page 87 to 128.
This is the inquiry.
And in page 82, the relevant place may I see the page 82 malleable, the relevant page number 82. That in that page malleable, that the government, the undersecretary malleable that to government, that he has replied, the government has already given the information to PK someone who is an activist malleable. In that receipt that
Yes, I am telling you, have you filed a complaint to the police or not?
Police that I have filed the complaint malleable.
Where that copy of the
that has been not attached malleable. That only then page number in my findings that has been
Stated case number.
the FIR number malleable. I have
We have doubt that you have filed any complaint to the police.
That has been by page 142. Page 142, clause 11, my lordship. That further I submitted the copy of the register FIR, copy Sujan number, PS number 57 of 113, my lordship. 5/4/113. 113, my lordship. Against the Sir Jamanikanta Das, my lordship, who has the opposite number 14, my lordship. Till that, only. And thereafter, after register the FIR, thereafter they are illegally promoted by the opposite parties, the government of Odisha.
Promoted.
This is not cannot be a subject matter of the public investigation.
Okay. And he has not, in page 82, my lordship, also
you are referring to paragraph 11 of page 142.
142. 142. Para 11.
The case was already registered 135 in 2013.
Well,
and it is already consideration and is pending before the appropriate court. Why have you come for the public interest litigation?
Public interest litigation that he has misappropriated crores of rupees, and not disclosing that the against the present petitioner or any other money. For that reason, I have even that as per the inquiry report,
why it will be disclosed to you? Who are you?
I am an activist, Melissa. That I was not involved in my inquiry report. I have
any report relating to the criminal investigation can be disclosed under RTI. Can it be done?
Because he was involved in the such minor irrigation project, my lordship.
You go and take the certified copy from the court.
I'll go, my lordship. That
we are not the facilitator here. Due process of the law has taken its course, and you are coming to this filing. You have a vested interest in the matter.
Vested interest, not my lordship. That at least a criminal action will be taken against the opposite party.
Taken.
Already been taken. Other opposite parties are involved also. They are not. They are not.
Give the evidence before the police. We are directing you.
I have already given all the evidence to the opposite parties, other opposite parties. They are not disclosing all the.
Disclose you that how they are investigating. They will not disclose you.
Page number 82 also they are admitted, the government
is there now. The police officer will go to you and disclose. This is the information I gave during my investigation.
They also violated the RTA Act, They also violated the RTA Act. Section 19, in section 19, clause 7, there is a process that if the information was shall be binding. That clause has been, they have disclosed, they have
section 8 of the RTI Act. 8 of the RTI Act.
That has been not
section 19 is relating to the appeal.
Well, that
you are referring an appellate provision before this court.
They have given the information to one person. They denied another person.
There is an appellate provision.
They have already. I have already approached the opposite parties. They have denied.
Asked for this appellate order or the order passed by the State Commission of the Information.
I only pray if a notice will be sought to the Malaysian
office. We don't issue any notice. We are thinking of imposing heavy cost on you. He was abusing the process of the court.
Well, if any time I urgent this question.
No, not a question at all. Just see, look behind all of them are waiting. We are wasting the time of the court.
And when the PIL, you are praying for withholding the financial and pensionary benefits of an opposite party.
That misappropriation of government money.
The government will take care of that.
I was also involved in the such minor irrigation such project work.
All right, they have taken.
I have in page.
All have seen. All have seen. Mr. The speaker.
I only pay for one urgent news. I some evidence are there. I
no, go to the police. We are giving you the liberty to go to
the police.
No, it's the police. We will not entertain this kind of petition. It is simple. Police investigating the matter. When you are coming to the court,
one agent. I will submit. I will.
I'll file the investigation register. The court doesn't have the authority to just poke their nose in the investigation.
I am satisfied, my lordship.
You cannot satisfy us. Sorry, Mr. Das.
I have apologize. One adjournment, I will satisfy myself.
Two, all right. No adjournment.
Next week, any date, ma'am.
Any, ready to waste time every time.
Next week, I will satisfy my lordship.
I think there is no scope of the intervention by this court. You have said you will convince us that this is not the first time. The matter was earlier also you are mentioning before us.
Not the first time. There is a fresh.
Right. That means you are filing the series of this kind of frivolous litigation.
No, that frivolous litigation I have not filed, my lordship.
Mr. Das, do you want us to pass order or do you want to withdraw?
Not withdraw, one adjournment, my lordship. One adjournment.
But
I mean, not adjourn the matter. Take it for
one dispute.
it's time, it is.
Case the time. What do you want?
15 minutes.
I'll just one date, my lordship.
no, nothing is there.
One date.
No, sorry. We are declining.
I'll
No.
And please do not give any guarantee to your client for which you are being so desperate.
Not
The case will stand on its own legs.
I will satisfy with my lordship permit. Only one.
No.
Next week, any date, my lord. Any date,
Of this
I apologize, my lordship.
by means of this petition, styled is the public interest litigation. The petitioner has asked this court to withhold the pensionary benefits and other financial benefits of the opposite party number 14, against whom the petitioner has made allegation of siphoning of the government fund at the time of implementation of the irrigation projects. Stop. It has been further prayed that in the course of the submission, Mr. Das and counsel has submitted that even though a specific criminal case has been registered against the opposite party number 14, being GRK, being Kobi Shurjanagar PS case number 57/2013, corresponding to GR case number 135 of 2013. The state opposite parties have been considering his name for promotion. It is the admission of the petitioner that the said PS case number 57/2013 has been registered under section 420, 425, 405, 406 /120B IPC. So in that case, not only opposite party number 14, other officers are also involved. Mr. Das has quite emphatically stated that the petitioner has evidence against them. So it is needless to state that if the petitioner is in possession of the evidence relating to the said Kabi Shurjanagar PS case number 57 of 2013, it is his duty under the Code of Criminal Procedure to place this evidence before the investigating officer. Otherwise, he will be also guilty of concealing the materials related to a criminal investigation. So, The main relief sprayed in this petition is cannot be the subject matter of a public interest litigation. At the time of granting promotion, the authorities always take care of whether any disciplinary procedure, whether any vigilance or criminal proceeding is pending against the person who is selected for promotion or not. Even the petitioner can file any complaint to the authorities who are supposed to consider the promotion of the respondent number 4, opposite party number 14. Stop. But the petitioner, without taking those recourses, has come by filing a public interest litigation. Stop. In view of what we have observed, we dismiss this petition. So, however, the petitioner may produce the evidence before the investigating officer of Kobi Shurjanagar PS case number 57 of 2013 or any government authority regarding the conduct of the opposite party number 4. But unless any allegation is proved in the judicial or the departmental forum, we cannot pass any order questioning the integrity of a public servant. No order is to cost.
I only pay influence last occasion. I also that my let's say approach the other offenses complaint has been before the evidence I have made the several representation has been given to the other opposite party.
Already you have observed it is not.
My lordship permitted one date. I did.
When you just now impose the cost, you are wasting the time and say that you have already supposed the criminal proceeding is going on. You go to the vigilance organization, file the records there. We have mentioned the vigilance authority are unless inquiry, we cannot investigate anyone. Yes, go there.
8. May I please? The petitioners before this PIL, my lord, the petitioner, my comprehensive prayer is that, my lord, the opposite party strictly follow the revised long-term plan which was formulated on account of acute poverty and, my lord, underdevelopment of the KDK region. Lordship, I have annexed that rule under Annex 1, my lord, that is page 11. Lordship, for a moment, kindly have a glance at page 11, my lord. My lord, this is the Biju KDK plan, modalities and guidelines, my lord. Well, the main objective of this plan is to, my lord, to elevate the poverty and, my lord, for better development of that KDK region, which is the, my lord, the most backward region of the country, my lord. And lordship, they have made a representation under Annex 3, my lord, which can be disposed of by directing the collector only OP number 3.
Well, have you stated that this,
my lord,
this program is not being implemented?
Well, it is not being implemented in accordance with the rules, my lord.
What is the deviation according to you? Where are you going to catalog the deviations?
My lord, lordship, may I kindly have a glance at page 7. Page 7, my lord, first para, my lord.
Yes.
My lord. But unfortunately, some political persons being hand in gloves with the corrupted government officer and using the government funds, as a result of which the benefit of said welfare scheme is not being reached directly to the beneficiaries, my lord.
All right. That is all.
Yes, my lord.
This is a kind of allegation you are coming in the public interest litigation.
My lord, they have staged.
For this, you are not to do any research. For this, you are not to go to these 3 areas that you have mentioned.
Yes, my lord.
You have not met the people. Who are the people they are getting not benefit? This is not the way the public.
My lord, I have completely stated everything in that, my lord, that representation, my lord.
What is statistical data that let us see in your representation?
Yes, my lord. 18 allegations are there, my lord.
Where is that the representation?
And it's a 2 page 16, my lord.
All right.
Well, that is in ODM, my lord. I have not.
All right, then my sister judge will read it.
Yes,
Let's
ma'am.
see what is the, given the specific details or not, otherwise we will not pass any order.
Yes, my lord. Let's say Annexure 2, page 16.
See whether the details of the persons who
urgent
issues, my lord.
ପ୍ରମାଣପତ୍ର ବଳରେ ଖଡ଼ିଆଲ କେନ୍ଦୁପତ୍ର ବିଭାଗର ରେଞ୍ଜ ଅଫିସର ଭାବରେ କାର୍ଯ୍ୟରତ ଥିବା ଶ୍ରୀ ସନ୍ତୋଷ କୁମାର ନାଇଡୁଙ୍କ
Nothing relating to the implementation of the program, not a single.
ପାଖରେ ଯଥାଶୀଘ୍ର
Well, everything is related to implementation of the program, my lord.
We appreciate that.
Everything related to,
But when you are challenging, you are saying they are deviating from any program, from its parameters,
Yes,
and
my lord.
standard procedure. You have to give certain specific information.
Your allegation first one is against a person who you are saying has obtained a fake caste certificate.
yes, my lord.
Second one, you are saying that students in English medium schools
They are not adequate teachers, my lord.
ଯୋଜନାରେ ବ୍ୟାପକ no, you are saying ଦୁର୍ନୀତି, corruption, that
Corruption.
is general allegation.
And my lord, CBSE cadre शिक्षक नियुक्ति दिया जाए नहीं.
So all these general things about
Serial 3, my lord, we can say serial.
Serial 3 is man.
CBSE cadre ର ଶିକ୍ଷକ ନିଯୁକ୍ତି ଦିଆଯାଉ ନାହିଁ.
Well, as per the program, there needs to be 100 English medium schools, my lord.
ହଷ୍ଟେଲ ର ସିଲିଆ ଦୀକ୍ଷା କେନ୍ଦ୍ର ଦୂରତା 10 କିଲୋମିଟରକୁ ଫିଟନେସ୍ ନଥିବା ବସ ରେ ଛାତ୍ରଛାତ୍ରୀ ମାନଙ୍କୁ ଗାଈ ଗୋରୁ ପରି so they are being transported in a bus which does not have fitness certificate.
Yes, my lord.
मेनू चार्ट अनुଯାୟୀ ଛାତ୍ରଛାତ୍ରୀ ମାନଙ୍କୁ ଖାଦ୍ୟ ଯୋଗାଇ ଦିଆଯାଉ ନାହିଁ.
They are not getting adequate food also, my lord.
ଜିଲ୍ଲା ପ୍ରଶାସନ ସ୍ତରରେ
My lord.
In which school they are not getting?
all ଛାତ୍ରଛାତ୍ରୀ, all this is all general, everything.
General school, my lord.
No, no, how do you know? Say that in this school I visited on this such and such, or a parent of the students visited and they found this is the requirement to be given to the students, but that was not granted on such and such date.
My lord, the petitioner who has filed this, my lord, is the General Secretary of the Jilla Adivasi Welfare Society, my lord.
Well, that whatever, he may be someone very important in other.
My lord, they have made a huge protest on 28, my lord.
That's all right.
And that was all electronic media.
He was protest and representative government, we believe for their own existence, they will take note of.
Well, when you come to the court, you have to give data information so that we can direct them on basis of that. Here you are given general.
I have made
This is like a
inquiry into the matter.
They
If
can inquire.
Every
Like
fall of that, we cannot direct.
Lordship may direct them to obtain instruction of lordship.
Just a swine.
This is too much. Okay,
Lordship may only pay my representation is to be considered.
all right. Mr. Kaushik Swan and counsel appearing for the.
Presentation addressed to Honorable CM.
All right.
That can be disposed of by the collector, my lord. For the
petitioners is a public spirited individuals. And he has filed the petition for direction on the appropriate authorities to strictly oblige the revised long-term action plan, RTLTAP, was the bracket, while implementing different tribal welfare schemes of the state government in the district of Noapara, taking into consideration the representation made by the Jilla Adivasi Welfare Sangh Noapara under Annexure 2 within a time to be stipulated by this honorable court. At the outset, we want to note the Jilla Adivasi Welfare Sangh, which filed the representation and the representation, Annexure 2 is not the petitioner, but its general secretary has come forward to file the petitioners. File the petition. Stop. We have perused the representation dated 28/7/2023, Annexure 2 to the read petition. The allegations are general in nature. Stop. From those allegations, no specific violation of the standard operating procedure or the guidelines as issued can be gathered. However, the purpose of the filing of the representation is that the modalities and guidelines of Biju KBK plan, whose purpose is to upscale the public investment in Koraput, Bolangir, Kalahandli, within the KBK region. Stop. The state government have launched the said initiative with a specific perspective plan, as briefly can be gathered from the Annexure 1. In the representation, some of the illustration has been granted, even though there is no specifics. We direct the opposite parties number 2, 3, 4, 5, 6, 7, and 8 to take a review of the implementation of the said program.
This is really impossible to dispose of the representative.
No, we are not directing. We are asking for the general review of the implementation. It is the duty of the government.
No, there is no specific allegation in the representation.
We are not asking them. Why are you so scared of? We are not asking even to the direct. We say they should make a review of their implementation.
Yes.
It is the duty of the government officer.
Yes.
His allegations are specified to Nuapada district.
Yes, my lord.
So for the Nuapara district is concerned, such review shall be carried out within a period of 8 weeks from today.
My lord, may confine it to OP number 3. Collector is the implementing authority in the district.
Because I think review will be carried already. We direct the opposite party number 2 to carry out a review of the implementation of this program within 8 weeks from the date when the petitioner shall supply a copy of this order. However, as a measure of abundant caution, we direct the registry to furnish a copy of this order to Mr. P.K. Mudali, non-election government advocate, who has appeared for the state opposite parties. But in future, Mr. Swain, I'm telling you, without doing the research, if you come in the public interest litigation, we'll just throw out this public interest litigation.
I'm extremely sorry, my lord. I will be mindful of that.
I'm going to mention, my lord, item number 44. It is a PIL matter. The pleadings is already completed. Can it be taken today, my lord? It can be discussed.
Comment too, that we are here. As long time permits, we'll take all the matters. Just be there.
And item 10, he is not pressing. The next
item not pressing.
He is not pressing.
You're not pressing.
Lordship.
Have you filed any any memorandum? You filed it, huh?
Lordship.
Just a minute. You are Mr. B. Mohanty.
B. Ponda.
You are Mr. B. Pondal, and counsel appearing for the petitioner has submitted that he has instruction to not press this present petition. Stop. The memorandum seeking leave of this court has been filed. For that purpose has been filed. You do not find any impediment in allowing the petitioner to not press this petition. Accordingly, this petition stands dismissed as not pressed. Mr. D.K. Mohanty, learned Division Government Advocate, has appeared for the state opposite parties. You filed the memorandum.
Memo they did.
Next.
Lordship.
Other matters.
Item 29, your lordship was put to direct to be listed on 2 p.m. That noting is not there.
You comment to.
Lordship.
Inform the council for the other side also.
State.
Is there? Is there? If time permits, we'll do it. What is your good name, sir? 47.
47. 47.
We'll pass the order later.
Mr. Kuntia is
mention our, yes.
Mr. Kuntia is there in 47.
We're not passing any order. Only.
Might not kindly have a date.
Oh, you engage one of your associates, they will collect the date. Because Mr. Kuntia is also not here, let him come and we will pass the order.
Pardon, my lord. And pardon, my lord, item number 54, can it be taken? Already informed the object by the council.
Just wait. First item, let me take us.
Item number 25.
Mr. Das is continuing with us.
Yes.
I mean, kindly pardon us. It's continuing. Let him continue.
Okay.
So only I have to submit one thing that in the batch of cases, you also have some repetition and also STRV, tax revision cases, which has come out of the order passed by tribunal. And in those cases, my friend has also asked to give a statement because I am also prepared charge. I am also handling your lordship.
Your lordship, in all these cases, your lordship, I have a prayer, your lordship. Your lordship, what I pray, the repetition of the constitutional validity of that proviso has been challenged in these repetitions. And against the tribunal's order, your lordship, some of the STRE state sales tax revisions have been filed. What my respectful submission before your lordship is that your lordship may formulate the law. Your lordship may decide the law whether it is ultra virus or not.
No, obviously, that is the purpose.
Exactly. So, because why I'm submitting, because in the sales tax revision cases, your lordship, many cases, your lordship, facts and circumstances are different. Your lordship, question of law, your lordship, besides 2J, other question of laws are there. So for that reason, your lordship may formulate the law.
You are absolutely correct. First, we decide the writ petitions. Thereafter, we'll scrutinize these writ petitions. If there is one additional ground, generally we cannot dispose of this on the ground of what you decide in the writ petitions.
Issue is similar. Because
in the charge, Mr. Mishra says there may be some additional grounds.
Some additional grounds are there also.
There is no additional ground, there is no difficulty.
No difficulty.
There is additional ground taken. Then, of course, you have to separately.
Correct. So what I am submitting was, because the chart your lordship will find the STRVs are admitted, barring 4 STRVs in which your lordship issued notice a question already framed in the petition itself, and those are to formally admitted. That is why I submit. But the other STRVs, your lordship already admitted question.
Okay.
And in the Lafarge India case, that is serial number belongs 2, 3, 4, and 5, 2, 3, and 4.
Yes.
These 3 STRVs, question is there in the petition itself. Those are to formally admitted. Only your lordship has to write admit bills. So that matter can be taken up together along with other batch. Notice already issued. Normally, your lordship formally pass order admitting which that is serial number 2 Lafarge India Limited STRV 26 of 2019 and 27 and 28 3 petitions there. Others are admitted. Modicare admitted, Gujarat Copper admitted, Madras Cement admitted.
Gujarat Milk, even copy has not been served to me.
So those have been admitted, barring these 3.
One matter, this STRV 19/2012, the Lafarge India is the respondent, this party.
That is the state division.
State division.
Submission, let it be lie over, let it be there in the list. Your lordship may decide the writ petition where the constitutional validity of the statute has been challenged.
Yes.
And after formulation of law, your lordship, that will follow your lordship in all these STRVs. And the question of law can be decided accordingly, your lordship.
No, if you say the question of law that has been framed in the petition itself, it's all can be taken on the very same date. If that undertaking you give for purpose of consideration of the revision petition, I have no difficulty to make them lay as it is now.
Your lordship, on the same day.
No, same. I am not checking. You so check up. Today you may not complete this part also. I do not know how much time Mr. Das will take.
I will not come up for time, your lordship.
10 minutes?
My lord, 15 minutes. My lord.
It should not be lawyers 15 minutes.
Then I have my clock today.
Yes, my lord.
I have to reply your lordship.
Now that is why I'm trying to be very precise because
Your lordship.
Because particular tax revision cases, Millards, because after finding of fact is recorded by the tribunal, then question of law arises from the order of the tribunal.
obviously.
So that's what
I'm asking Mr. Mishra to consider whether the question that has been suggested by the petitioner.
Correct.
Whether if that is covered, he will find any difficulty.
Then Millards, I think that's the only question which I have already been addressing, the 2J.
Okay.
Nothing more, nothing less.
So this is the same question. So
Same question to formally admitted. Question Millards in all the tax revisions cases admitted.
already just
Questions are same. Very few ancillary questions which your lordship may take into consideration later.
and that is why he has pointed out that in some cases there may be few ancillary questions may be there. So today we may not complete it because it's already 2:15. So I would request the council who are appearing for the petitioners on the STREV cases, they should just against his case, the additional questions beyond 2J question, what are there, they just give a catalog. That's so that we can pick up all the matters together. Right? Yes, Mr.
Yes,
Das.
my lord. Grateful, my lord. My lord, the last occasion, your lordships,
Yes.
in order to substantiate my claim that the rule provision to section 2J of the OET is not
Just for my memory, in which case now you are appearing?
My lord, I'm appearing in STRA number 50 of 2016, my lord, in the case of Cone 11, your lordships.
50.
50, my lord.
I know this.
50 of 2016, my lord.
Oh, 16, okay.
2016, my lord.
15, 15.
50, my lord.
Okay. This is a Cone Elevator,
Yes, my lord.
private limited?
My
Okay.
lord. Yes, my lord. You need to substantiate the fact that the goods which is accompanied with the delivery challan cum excise invoices under Rule 11 of the Central Excise Rules 2002 and also under the Stocks Trans Advice under Section 6 Capital of the CST Act.
Yes.
In the circumstances, the provision to Rule 2J shall not be invocable for the purpose of valuation, your lordships. In the substantiate, I have submitted before my lord a paper book compilation of paper book, your lordships. I just request my lord to kindly revisit the paper book, my lord.
Let's keep the paper book, my lord. Yes.
My lord, page 1 of my compilation, your lordships, in the vertical form, my lords.
Yes.
So that is the delivery challan cum excise invoices, your lordships. The highlighted part subsequently shows that the delivery challan cum excise invoices, Rule 11 of the Central Excise Rules 2002, your lordships.
Yes.
My lord, kindly turn to page 4, my lord. Page 4, your lordships. The highlight part again contains, your lordships, value of the excise goods, excise duty, sales, and total, your lordships.
So for purpose of the Excise Act, that is valued.
Yes, my lord.
Your contention is that the same value has to be accepted by for the other purpose also.
My lord.
Such as the entry tax.
Yes, my lord.
That's all contention.
I'll just have a few seconds, your lordships.
Yes.
Why I am saying so? First, you kindly turn to page 6 of my compilation, your lordships. 6, the highlight para Rule 11, your lordships.
Yes.
Goods to be removed on invoices. Rule 11. 1. No exchangeable goods shall be removed from the factory or a warehouse except under the invoice. My lord, kindly note invoice signed by the owner of the factory or his authorized agent. I stop there, your lordships. Lordship, kindly turn to page 7 of the last immediate page, your lordships. Sub-rule 2, my lord. The invoices shall be serially numbered and shall contain the registration number, address of the concerned syntaxis division, name of the consignee, description, classification, time and date of renewal, mode of transportation and vehicle registration number, rate of duty, quantity and value of the goods, your lordships.
Yes.
And the duty payable thereon, your lordships. So the excise invoices removed under Rule 11 will also contain the value of the goods and excise duty payable, your lordships. Lordship, the subsequent highlighted para, your lordships.
Yes.
The invoices shall prepared in duplicate in three of the following manner, namely, one, the original copy being marked as original for the buyer. Second, the duplicate copy being marked as a duplicate for the transporter. Third, the duplicate copy being marked the duplicate for the assessee. So this is the invoices under the Central Excise Act, read with the Central Excise Rule 11 of the Act, lordships. Now, lordships. And
so the buyer is of can be anyone.
Buyer can be the agent or the branch or the unrelated person also, my lords.
Yes.
My lords, now under the GST, there is a concept of supply of goods and services are here.
Yes.
But prior to GST already under the As-12 CST Act and OVT Act, the concept of supply was not there. The concept of sale was there, your lordships.
Yes.
The petitioner being a corporate, your lordships, the registered office, the branch office and the head office are belong to the same entity, your lordships. That being the cases, being the same person, even in transfer property held, they cannot raise the invoices, there cannot be a sale, your lordship. In order to avoid such, your lordship, in order to overcome such difficulty, a mechanism has been developed under Section 6 capital A of the CST Act, your lordships. Six capital A, my lord.
Yes.
My lord, kindly turn page 9, your lordships. Compilation. Burden of proof, etc. in case of transfer of goods claim otherwise than by a sale, your lordship. With the permission, I will read out the reproduction, your lordship, which is relevant, your lordships. Where a dealer claims that he is not liable to pay tax under this act, CST Act, your lordships, in respect of any goods on the ground that the movement of such goods from one state to another was occasioned by reason of transfer of such goods by him to any other place of his business or to his agent or principal, as the case may be, and not by reason of sale. The burden of proving the movement of goods of those goods was so occasioned shall be on the dealer, and for this purpose he may furnish to the assessing authority within a prescribed time or within such further time as may be authority may, for sufficient cause, permit a declaration, my lord.
Yes.
Duly filled in and signed in by the principal officer or other place of business or his agent or principal, as the case may be, containing the prescribed particulars in the prescribed form, obtained from the prescribed authority, along with the evidence of dispatch of such goods. And, my lord, kindly take note, my lords, if the dealer fails to furnish such declaration, then the movement of such goods shall be deemed to be, for all purposes of this act, the occasional result of sale, my lord. My summation is that, your lordships, the same excise invoices on which goods have been delivered, dispatched, your lordship, is also the delivery challan under Section 6 capital A of the CST Act, your lordship. If it is to be treated as stock transfer, if it is supported by the declaration form, your lordship. In a failure to file the declaration form, it will be treated as sale. Exactly, my lord. I am not going further, your lordships. My lords, page 15, your lordships. The form F, your lordships. Page 15, my lord.
Yes.
This is the form F, your lordship. It refers to among the details of description which contain description of the goods sent, quantity or weight, value of the goods which I have highlighted, your lordships, and number and date of invoice or challan any kinds. My lord, these invoices have been obtained from the sales tax authority under the CST Act, from the consignor's place and dispatched to the consignor's place, your lordship. The authority under the sales tax of both the end, that is the receiving end as well as the dispatching end, has accepted the stock sponsor and the value contained there, your lordships.
Yes.
And under the OVAT Act, your lordships, this value has been accepted by the authority, your lordship. My submission is that when all the authority under the Central Excise Act, CST Act and OVAT Act being the same authority under the ET Act, they should not have a different view in order to for the purpose of invocation of Rule 2J for the purpose of valuation, your lordships.
How do you say they are the common authority under the GST or?
Yes, my lord. The assessing authority under the Anti Tax Act is also the assessing authority of sales tax under the OVAT Act, and he is also the authority under the CST Act, your lordships.
No, it may be three different persons.
No, it's the same person. They are working in a different capacity.
No. That the Act provides, it is for the convenience that one person is made the assessing authority. Whether the Act prohibits that there cannot be three or persons.
No, my lord. No,
I'm telling you, it cannot be a legal proposition.
I rectify my
yes, that you cannot do.
So my submission under other acts also, this value also been accepted, my lords. My submission. Kindly noted here.
That up to that is okay.
Yes, my lord.
That when it was through a statutory process, value is declared, unless there is a very strong reasons to disbelieve it for any other purpose. Because that should be usually accepted. That is your contention.
My lord has already revisited section 2J several times, your lordship. But for only for a few seconds, I want to revisit section 2J at page 20 plus 20, my lords.
Yes.
I am not going to the 2J, your lordship. I am going to the provisional part, your lordships.
Okay.
Which is under challenge, your lordship. Provided that where purchase value of any scheduled goods is not ascertainable on account of non-availability or non-production of original invoices or bill. Second, or when the invoices or bill produced are proved to be false. Or third, if the scheduled goods are acquired or obtained otherwise than by of a purchase. In these circumstances, Rule 2J shall be provided to Rule 2 shall be invoked.
The goods are required. It should be
acquired, lordship. That may be acquired. Acquired. This is printing mission. Serial number 3. Kindly note of serial number 3. What required is to be required.
Okay.
Yes, my lord. Well, there are three conditions under section 2J shall be invoked. One, no bills produced. Second, bills produced to be false. And third, no purchase bills.
That has been argued already. Okay.
Yes, ma'am. I'm not on that point of. My lord, kindly have it to the three of the condition.
Yes.
That all the condition means no invoices have been produced, your lordships. Okay. In this case, your lordships, the revenue want to say that I am covered on the third condition, that is, scheduled goods are purchased otherwise than by acquired otherwise than by purchase, your lordships. My lord, the first condition, no bill. The second condition, false invoices, and the third condition, no purchase. No purchase amounts to, my lord, no value, your lordship. That means in the cases goods have been received otherwise than purchased as a tax-free goods or as a without payment of tax, without value, your lordships. That is the intention to incorporate the third triangle. It never intend to say the goods which in accounting to excise invoices and also the invoices under section 6 capital of the Act accepted by the format cannot be brought in this third circumstance, your lordships. This is fine support from the principles of association of society, your lordships. I invite to the attention of the prosecutor society, my lords. My lord, page 4 is the order of the Honorable Supreme Court in the case of Oswald Agro Mills Limited v. Collector of Central Excise. I invite to state to page 27, your lordships. Page 27, your lordships.
This is a textbook.
This is from the Escorts Library, your lordships. Page 24 is the
commentary book, I think.
My lord.
But judgment is there, no? They have printed the judgment also.
Page 24, my lord.
Well, come to the judgment straight.
Judgment citation
27.
1993, 66 ELT, 37 Supreme Court, my lord. Oswald Agro Mills Limited versus Collector of Central Excise, your lordships.
Yes.
My lordship, kind invite to page 27, your lordships.
Yes.
The highlighted part in the serial number 3. This entry is amended in 1964. Reads thus: 15. Soap means all variety of product known as commercial soap. 1. Soap, household and laundry. And second is other sorts, your lordships. The interpretation of record whether the toilet soap shall be covered under the entry household or not, your lordships. Therein, my lord, is held that toilet soap being a household soap, it draws meaning from the earlier words, your lordship. While analyzing say so, they have given the principle deciding, your lordship, as page 31, your lordships. Page 31, your lordships. The highlighted part you are reading down, your lordship, permission. There is no quarrel with the preposition that in ascertaining the meaning of the word or a clause or sentence in the statute, in its interpretation, everything which is logically relevant should be admissible. It is no doubt true that the doctrine of Noskistar Soci, meaning thereby that it is a legitimate rule of construction to constitute words in an act of parliament with reference to the words found in immediate connection with them. That is, when two or more words which are susceptible to or analogous meaning are clubbed together, they are understood to be used in their cognate sense. They take it where they are colored from each other. The meaning of the more general is restricted to a sense analogous to a less general. This philosophy behind is that the meaning of doubtful words may be ascertained by reference to the meaning of the words associated with it.
So they are going to the broader principles now.
They are not going to do the broader principle. They said that it will draw the meaning from the previous sentence of the previous words. My submission is that the word in the third circumstance of Rule 2J says that if when the goods are not being purchased, your lordships, and the prior entry says that no bills have been produced, or the bills produced to be a fake one is an incorrect one. So the third circle, no bills produced, the goods which are brought under the state of excise invoices cannot be brought under this third circumstance of embargo, your lord. That's my submission, your lordship.
Cannot be brought.
Cannot be brought, your lordships.
The stock of exchange will not be covered by stock of these goods cannot be, stock exchange cannot be just
on the third circumstances, yes. That is goods without being purchased.
There is a third circumstance. So,
my lord, this also will subsequently also the Honorable Supreme Court in the case of Pradeep Agrawati at State of Punjab, page 33, your lordships. 1997, 96 ELT, 219 Supreme Court, your lordships. Pradeep Agrawati versus State of Punjab, your lordships. Similar view also held, your lordship, that therein the issue, your lordships, that when the entry says that, page 34, my lord, the next page, your lordships. Serial number 3, your lordship, when entry serial number 16 of the schedule A to say that the relevant time reads thus cosmetic, perfumery and toilet goods, excluding toothpaste, tooth powder, kumkum and soap. The reference is made whether the group and agravati shall be covered or not that. Therein it is held that it is not covered because this is not the cosmetic, your lordships. And the relevant provision, your lordships, page 35, para 9, your lordships. Next page, your lordships.
yes.
Para 9, your lordships. Entries in the schedule of sales tax and excise statute list some of articles separately and some articles are grouped together. When they are grouped together, each word in the entry draws color from the other words then therein. This is the principle of Noskistar Soci, your lordships. So my submission is that, so the third circumstances shall be in comparison to first two said, that is non-production bills and fake invoices. Yes. So I will not cover by that entry third circumstance, your lordships. My lord, my seniors already referred to the case of Voltas Limited, your lordships, where it is held that the stock transfer invoices is not highly, it should be a provision to invoke, your lordships. I just go to the last page of the order, your lordships. This is a circumstantial order, your lordships. This is not an absolute applicable to each and circumstance, your lordships. Page 44, your lordships. Para 12, my lord.
Yes.
The said conclusion reached by the appellate authority was also affirmed by the tribunal. In this connection, it is useful to refer the observation made by the tribunal at paragraph 8 of the order, which reads as follows. 8. The value of the goods under Entry Tax Act is defined under section 2 capital A within bracket 8 small a of the Act, is reads as under. Value of the goods shall mean the purchase value of the goods, that is to say the purchase price at which a dealer purchased the goods inclusive of charges borne by him at the cost of transportation, packing, forwarding and handling charges, commissioning, insurance, taxes, duty and likes, or if such goods not been purchased by him, the prevailing market price of such goods in the local area, your lordships. Coming to the next part, the provision is very clear. The latter part is in material for us, since the applicant did not purchase the goods, but they were stock transfer. The law lays down that if such goods had not been purchased by the dealer, the entity tax would be levied on the prevailing market price of such goods in the local area. Thus, rightly, the authorities below added the gross profit to the price of such goods, price of the stocks transfer and levied entity tax. The learned counsel of the applicant submitted that the turnover tax by the authority below the inclusive profit, storing, marketing, etc. But the contents is very vague. The applicant has, lordship, next page, lordship, has not specifically given the cost of made by for storing, marketing, etc. The next para, your lordship, though it is contended that the value of the goods arrived at by the lower authority was the sale price declared in the Central Excise Department, the applicant has not produced any material to show the sale price declared it before the Central Excise Department. Thus, under these circumstances, my lord, we are not find any reason to interfere with the impugned order of the first appellate authority. This is, my lord, in my cases, I produce the excise invoices accompanied with the 6A transfer invoices. So this order of the Honorable Karnataka is not applicable to me, your lordships. And furthermore, lastly, your lordship, I take only 2 minutes, your lordships. The para 58, the Council Corporation also minded gone several times. I'm not going to buy that, your lordship. Coming to the impugned revision petition, your lordship. In my case, your lordship, I inviting the attention order of assessment, your lordship, page 28, your lordships. Yes. Revision petition, page 28, your lordship. So, sorry, page 30, your lordship, 30. Page 30 order of assessment is second para is the Paul lordships. The company received scheduled goods worth of 5,50,56,001 from the outside branches on stocks transfer basis and paid entity tax on the said value. This value is not the actual purchase price because the original purchase invoice is not available and the goods are received on stocks transfer. Under the order of assessment, provision to section 2J has been invoked, your lordship, on the absence of original purchase invoices, your lordship. Coming to the first appeal order, your lordships, that is at page 33, your lordships. Last but one para, your lordships. In all the 3 efforts mentioned, Lord, did I read down, your lordships?
Please go ahead.
In all the 3 efforts mentioned scenarios or situation, law mandates the purchase value shall be the value of price at which the scheduled goods or like kind of quality is sold.
The Pradeep Agarbatti, no.
My lord?
You are reading from where?
Sorry, I could not get you, my lords.
Are you reading from Pradeep Agarbatti?
No, page 33 of my revision petition.
Petition.
My lord. Sorry, I could not properly communicate it.
Yes.
Page 33, your lordship. Last but one para, your lordships. In all the 3 aforesaid mentioned scenarios, or situation, law mandates the purchase value shall be the value at price at which the scheduled goods or like kind or quality is sold or is capable of being sold in the open market. In other words, the provision mandates determination of purchase value for the purpose of levy of tax on the basis of market value of the goods which are brought into the local area. law does not provide assessing authority with any other option. In the case of the applicant, it cannot be denied that scheduled goods have been brought into the local area other than by a purchase, your lordships. The order of assessment say, I am failed to produce the original invoices. The first appellate authority say, goods have been purchased otherwise than purchased. And the tribunal said, your lordships, stocks transfer, procuring the goods, stocks transfer is a result of the avoidance of duty, your lordships. My lord, page 41, your lordships. Page 41 of the revision petition, my lord.
41.
Yes, my lord.
Yes.
Yes, my lord. The second line, your lordship, the elevator is brought by the dealer appellant from its own branch outside the state on stock transfer basis gives enough scope to dealer to undervaluation the same for the purpose of not paying the actual empty tax of the state exchequer, since it is a transaction between the same parties. Moreover, such type of stock transfer is a contravention to requirement of section 2J of the OET Act. My submission is that order of assessment demands me empty tax on the ground of non-submission of original bills.
Yes.
The first appellate authority confirms the demand on the ground of receipt of goods otherwise than the purchase, and the tribunal confirms the same also on the ground of that there is a scope for undervaluation for not paying the appropriate duty or receipt. So neither of the authority confirm on what ground, under which circumstance they are going to reject it. Only for the sake of confirming the demand, they are confirming the demand. In view of the above, my submission that Rule 2J, provision to Rule 2J is not invocable in my case, my lord.
Yes.
I have prepared a short brief notes, kindly share with my lord.
Yes. All right, these are all you have already argued.
Yes, ma'am.
Thank you for it will use as a reminder.
Grateful, ma'am. I'm grateful. I'm grateful. Yes.
May it please us. I completely adopt the legal submission made by
Would you like to add something?
No, my case, I'm in STREB 73 of 2014.
Only one case.
Only one case. And in this case, the peculiarity is here I have paid tax on the sale price.
Okay.
I've already paid tax on the sale price. Beyond that, the
case number is
73 of 2014.
14.
Yes, sir.
You are Mr. Sahu.
Mohanty, let's say. A.K. Mohanty.
Ashok Kumar Mohanty. Thank you.
Yes, here what has happened, I'm a consignment agent and I obtain goods from my principal through branch transfer on furnishing form F as my Lord India, Mr. CORAM was addressing the lawsuit. And on receipt of it, I am required to sell it to the wholesalers at the price determined by my principal. So the stock transfer occurs with the value of STN value, stock transfer note value, Lordship. So my instruction from my principal is to sell it at the same price at which the stock transfer note is prepared. So to avoid this legal issues with regard to entry tax, it has been decided to sell it at the stock transfer has to be prepared at the value which it is to be sold within the state. So there is no dispute with regard to on facts that I have sold it on stock transfer note value, Lordship.
All right.
The assessing officer went on to assess me, adding VAT to that stock transfer note value. He said that for the purpose of entry tax, my turnover should be, since it has been received through otherwise than by way of sale, it should include VAT. So I went in appeal before the first appellate authority. In the meanwhile, this Commissioner of Commercial Tax also had issued a clarification on request from some of the assessing authorities whether it should include VAT or not. And in that clarification, the Commissioner of Sales Tax clarified that a taxable event under the Entry Tax Act will always occur after the entry of the goods into the state. So before the sale made in the state, within the state, under the VAT Act.
So according to the VAT cannot be added.
No, so the VAT was excluded by the first appellate authority. However, first appellate authority went on to add a ad hoc 3% towards freight lordships. So, for no reason assigned, 3% freight was added beyond my sale price. My lord would appreciate when I am selling a commodity at a particular price, I have already included my overheads, my principal profit, my commission, everything has been taken care of. Otherwise, unless I am going to sell it for a loss, I have included everything over there. Beyond that, and also the freight inwards. And everything beyond that, the additional commissioner of the appellate authority, he added 3% freight arbitrarily. So I went before the tribunal, and the tribunal called for the documents, the very invoices of the purchaser and the seller. The tribunal recorded a finding that they found that it has been sold at the stock transfer note price. That is my selling price. And yet the tribunal went on to hold that this 3% of freight should further be added because I could not produce any document that freight has not been borne by me. That's it. The very idea of the sale price is it has included everything. The tribunal has confused itself completely by allowing it the addition to continue, and that is my case, Lordship. Since I have paid it on the sale price, there could not have been any further addition to that for the purpose of even assuming that the 2J is a valid in this case.
If you contend this way, virtually you want to come under the provisions of 2J, you are not challenging it.
In this case, the validity of
you say that I have the stock transfer was concerned with the same value.
I have sale value.
And your sale value is equal to the your purchase value.
Not purchase value, that's it. It's a stock transfer. That's it. I have sold it at a price on which, even assuming that 2J is valid, still nothing more can be added to my sale price for imposition of entry tax, Lordship. Even assuming that 2J is valid. That is my case, Lordship. So, okay, Lordship.
Yes,
that's
yes, Mr. Mishra.
Lordship, for better appreciation of fact, I have prepared a written note of submission, Your Lordship. So, Lordship, I am fortunate to argue this case, but it is the unfortunate of the act of this statute, Odisha Anti-Tax Act. Since Odisha Anti-Tax Act has been introduced in 1999, it has been faced different challenges at different time, Your Lordship. It has been the entire act has been challenged at different time, Your Lordship. Sometimes it is contravention of 301, Article 301. Sometimes it is violative of Article 14. Sometimes it is 19(1)(g). And many more challenges, Your Lordship, at different occasions from 1999. Your Lordship, the challenges going up. Your Lordship, what happened? In the year 2008, Your Lordship, this Honorable Court has passed the final order so far as that ultra-virus is concerned, so far as the statute is concerned in Reliance Industries. That's a state of Odisha, Your Lordship. That has been reported in 2008. Your Lordship, I'll go to this, Your Lordship, just it is my introduction. Yes. 2008, 16 STC 85 Odisha. This Honorable High Court has decided the constitutional validity of this Odisha Anti-Tax Act. Your Lordship, by declaring that it is constitutionally valid, only a paragraph 30 of the judgment, this Honorable Court has said that the state cannot levy any tax since when the goods have been brought from outside of the state and not manufactured within. Subsequently, that has been challenged. Many SLPs, 300, 400 SLPs have been filed to Honorable Supreme Court. Honorable Supreme Court Division Bench, three judges bench, 5 judges bench, 7 judges bench, 9 judges bench, it has been referred. And 9 judges bench has been decided in the year 2016, Your Lordship. In case of Jindal, Stainless versus State of Haryana, all the cases of Odisha cases have also been decided. Your Lordship, Honorable Supreme Court 9 judges bench has been laid down the law by declaring that it is improvirus, constitutionally valid. It is as per NP 52, Your Lordship. It is as per Article 246. There is no violation, Your Lordship, so far as the Anti-Tax Act is concerned. Your Lordship, if Your Lordship can permit me, then one judgment, only one paragraph.
All right.
Only one paragraph of this judgment.
Before that one question, that means
I try to answer Your Lordship.
the first question first. You mean to say when you are contending that that has been already examined by the 9 judges bench of the Supreme Court, there is no necessity.
That is not my submission. That is not my submission.
Extreme. That is why I am asking you.
That is not my submission.
Because the challenge in the judgment was very specific. That was not relating to the value of goods. Section 2.
Your Lordship, I'll answer all your queries, Your Lordship, because many questions might have been in Your Lordship's mind. Your Lordship, I'll after my argument, Your Lordship. But Your Lordship, may kindly allow me to present here. Your Lordship. So, I'll submit that judgment, Your Lordship. Subsequently, Your Lordship, also, in state of Kerala versus William Fernandez, entry 52 has very widely, Your Lordship, has been decided how the Entry Tax Act is as per the Constitution. As per the mandate of the Constitution, this Entry Tax Act has been introduced. Now, Your Lordship,
nobody, Mr. Mishra, there is be a more brave. Nobody has questioned the constitutional validity of the entry tax.
Your Lordship, it is the provision. Your Lordship, I'll go to the provision, Your Lordship. Directly, Your Lordship, I'll my arguments, Your Lordship, so far as the constitutional validity. Let me argue so far as the provision is concerned. Now, Your Lordship, what is here? The charging provision is section 3. Your Lordship, before starting my argument, Your Lordship, I just draw Your Lordship's kind attention. And Your Lordship, I just pray Your Lordship, kindly let me go through that section 3 very slowly, Your Lordship. Why slowly, Your Lordship? Your Lordship, why I am going slowly? Section 3, Your Lordship, that is the charging section. There shall be levied and collected a tax. Your Lordship, each word has a meaning. Each word has an interpretation, Your Lordship, which has been wrongly misinterpreted by the. There shall be levied and collected a tax on entry, Your Lordship, on entry of the scheduled goods into the local area for consumption, use, or sale therein at such rate not exceeding 12% of the purchase value of such goods from such date as may be specified by the state government, and different dates and different date may be specified by different goods and local areas subject to such condition. Lordship has already gone through the judgment of Honorable Supreme Court in the Gangacharan case. In order to levy the tax Yes. So the ingredients have to be satisfied. What are they? Well, let's say taxable event, taxable portion, rate of tax, nature of tax. Here, let's see, this section 3 fulfill all the conditions. How you let's see? There shall be entry collective tax on entry of the scheduled goods, entry of the scheduled goods into the local area. So here you must see what my learning senior on the last occasion has argued. Entry tax and purchase of the goods. Entry of the scheduled goods. That may be purchase, that may be branch transfer, that may be consignment transfer, whatever may be, on entry of the goods, you have to pay the tax. That's the taxable event. Who will pay the tax? The taxable portion here, your lordship, that who brought the goods. Now, your lordship, another tax is there. Major tax, the purchase value, your lordship, that is there on the purchase value. That is the major of tax. Now, your lordship, your lordship, my kindly turn to my note, your lordship, page 4. When the scheduled goods, your lordship, page 4, the last paragraph, when the scheduled goods enter into the local, already I have argued that all these 4 ingredients are there. So, in the matter taxing statute, your lordship, Honorable Supreme Court has very categorically stated, very clearly stated that in the matter of taxing statute, the legislature enjoys a larger discretion in the matter of classification so long as it adheres to the fundamental principle underlying the doctrine of classification. The power of legislature to classify is a wide range and flexibility so that it can adjust its taxation in all proper and reasonable ways. Legislature which is competent to levy a tax must inevitably be given full freedom to determine which article should be taxed, in what manner and what rate. In tax matter, the state is allowed to pick and choose district, object, portion, methods, even rates for taxation if it does so reasonably. In February and Company, I will give the judgment, your lordship, I will submit. The context of the petitioner that the charging section under section 3 has only provided the scenario of purchase, not the situation of receipt of scheduled goods. One amount of stock transfer is misconceived. Why, your lordship? Because the taxable event arises only on entry of goods. The taxable event has nothing to do with transaction of purchase or sale for which it is a non-transitional in nature. So now, your lordship, suppose the section 3, the nature of tax has been described and the nature of tax has been defined under section 2J of the Act. Sorry. Your lordship, for a moment, your lordship may kindly turn to 2J. The purchase value. Purchase value means the value of scheduled goods as ascertained from invoice, original invoice or bill, and your lordship, very important, and includes insurance charges, excise duties, countervailing charges, sales tax, value-added tax act or value-added tax. Subsequently, it has become value-added tax, or as the case may be, turnover tax, transport charges, freight charges, and all other charges incidental to the purchase of such goods. Let's say this purchase value, after section 3, this purchase value means the value which has been mentioned in the original invoice, and including all these. This is not challenged. This has not been challenged in all these cases here, so far as this is concerned. So the purchase value, the meaning of purchase value, the measure of tax has not been challenged, and it has to be ascertained from the original invoice and includes all so and so till entry of the goods. That's it. Again, I am submitting whatever may be. Everything is till entry of the goods because the taxable event arose on the entry of goods. That is very important. You may kindly turn to that provided. Provided that where purchase value of any single good is not ascertainable on account of non-availability or non-production of original invoice or bill. When the invoice or bill produced is proved to be false, or if the scheduled goods are or obtained otherwise than by way of purchase, then the purchase value shall be the value or the price at which the scheduled goods, very important, the scheduled goods of like kind, not that scheduled good, not that particular good which has been entered into the local area. Similar kind, like kind or equality, quality, like kind or quality, it's sold or is capable of being sold in open. Not, your lordship, the influence of legislature is very clear, which has been misunderstood. Why?
There is no misunderstanding.
Why I'm saying so? Or let me submit your lordship for a moment. Why I'm saying this is the meaning that what they understood, that the same price, which is at a later date, and the goods has been sold, that price is will be the purchase price. That is not the case here. Here the case is that the entry, today it has been entered into the local area. So at the time of entry, what is the price? What is the market price of the goods, same or the similar goods at the time of entry? So it's not that it will be increased and decreased at a later date. Because suppose today I purchased. Today the goods are
so that we let us come to on the focal point. There can be several circumstances. And three circumstances have been illustrated in the provision itself. Right? So it says that when these are not available, third circumstance, then the authority can go for finding a value from all the incidences of price.
No, lordship, why I am saying so, this part, your lordship, all these parts, this first 1, 2 is the assessing officer's part. But the third part is the disclosure made by the dealer himself.
Yes.
Your lordship, because it cannot be. Because it cannot be. Why your lordship? Today the goods have been, this is not the intention of legislature. Why your lordship? Because today the goods have been entered. But the entire taxable event arises at the entry point, your lordship. Goods will be sold after 1 month or 2 months. The purchase may vary, the price may vary, the price may be increased, may be decreased. So that's at that time.
What is the question? It's something the same thing with the physical point. But the point of time is also very important for this purpose of dimension, because when that enters, it will be the point of time. Not in the future time. This is I'm pointing.
Yes. Because we cannot go beyond 1952. Because state legislature, why you lordship, your lordship may kindly look into. Then the purchase value.
Things, yes. Yes.
Your lordship. Then the purchase value shall be the value or the price at which the scheduled goods of like kind or quality it's sold as capable of being sold in open market. On that day, at the point of entry, what is the Karnataka Voltage case, if I go to lateral, that is very bad, bad than us. In that, the language is such good. Same price of such good. Here in Orissa, we have stated that same kind or quality. Not such good. If such good is there, then what you the question?
Every provision has its limited elasticity. If you draw beyond it, we will be nowhere. So please, because you read how this started, the proviso started. Where the purchase value of any scheduled goods is not ascertainable on account of non-availability and non-production of the original invoice or bill, or when the invoice of the bill produced is proved to be false. So the first, there is no difficulty. Right. So what is the point in time? Point in time is the entry point.
Exactly.
And when those two incidences are not fulfilled, there are occasions in the situation how to ascertain the value of the goods. Then the other provisions can apply.
I'm sorry.
And then also, the argument has been made that in case of a class of a transfer, that cannot also be applied. That has it has been argued. But thus,
Your Lordship. Your Lordship.
no, this is very important. Import, that is the concern. Of course, it has been argued. When the goods will be sold in the future point of time.
Your Lordship.
My question is, can it be taken when the entry tax is concerned?
Exactly. Why I'm saying
because the incidence of tax, whatever, is only the point in time is when the goods enter into the local area.
Your Lordship. Your Lordship, why I'm submitting this? Why I'm submitting this?
No, because I'm trying to understand from you what the purpose of this
ingredient. Three ingredient which what your Lordship has pointed out.
Keep in mind that this provision has been challenged, this proviso, because of this uncertainty.
Your Lordship,
because if you interpret this way, this will give an uncanalized and unbridled power to the assessing officer.
No,
that's one of the objections. Yes.
Your Lordship, these three ingredients provided, Your Lordship, these three are different occasions. These three are not same. Your Lordship, the number one is that, number 1 and 2 are that, when the purchases have been made, and the purchases in absence of original invoice, number 1. And number 2 are not ascertainable. And when that pattern become false. The third is that, when the husband, this 2 point, the assessing officer is to
yes.
But our point in actually, this is one, it has been included the same money law. For that reason, it can be misunderstood. What the intention of legislature is that, provided or if the scheduled goods are all obtained otherwise than by purchase, so it is all along in different categories. You not say the goods purchased. The purchase, one is purchase, another is one transfer. So on both taxes is to be levied. So on both taxes is to be levied because the entry at the entry point, the tax is to be levied. So you also here, such goods might have been there. Some point that it will be at a later date.
My proposition is very clear.
Your Lordship.
There is no import of the later or future date. According to the proviso also, if we interpret it as what is exactly available now, it only says the capable of being sold in open market. That also imperatively shows that at that point of time, what will be the capable of being sold? Not also in the future or subsequent time. This means that there is no question of considering the potential price. That is what.
Your Lordship, in my note also I have clarified how this scenario, Your Lordship may kindly turn to page 7. Page 8, the first. Your Lordship, page 7, I have illustrated that 2J and page 8 on occurrence of any of the event, either 1, 2, 3 stated in the second part. The purchase value, measure or levy shall be the value and price at which serial good of like kind or quality is sold or is capable in open market. The case of the petitioners, all the petitioners are under scenario 3 for which it is liable to make payment of tax and measure of tax as delineated under the proviso 2J. So what my point is that it is only submitted that it is straight law that by charging section controls the measure of tax. Converse is not true. Once the petitioner does not deny its liability, Your Lordship, Now, your lordship, it is only submitted that the provision to a particular provision of statute only embraces the field which is covered by the said provision. It carves out an exception of the provision which has been enacted as a proviso. The proviso under section 2J has been introduced to meet the requirement of for an exception. Your lordship, why? What is the intention of legislature? Why this proviso has been inserted? Your lordship, just I may be permitted to place one example. Your lordship, one case how the revenue loss is there. If your lordship at all, this provision will be deleted. Your lordship, for a moment, your lordship may kindly look into the second brief. There is a table, your lordship, the second brief, your lordship, at page 67. Your lordship, I'll go, other thing, so far as the stock transfer note and so far as the CST, your lordship, I'll go. For a moment, your lordship may kindly.
14069.
Your lordship.
Dover India Limited.
Lordship. Yes, 67. The allegation, your lordship got it.
Just a minute.
Yes. Your lordship. The allegation in the EPR also score is examined reference to the written submission of the learned advocate and the statutory provision of 2J of OET Act. From the above provision of law, under section 2J of the OET Act, it is found that when scheduled goods are acquired and obtained otherwise than by way of purchase, received either by way of stock transfer or consignment sale, the purchase value for the purpose of levy of entry tax shall be the value or the price at which scheduled goods like kind quality is sold or is capable of being sold in open market. The said norm of taxation under OET Act in case of receipt of goods otherwise than by way of purchase has no relevance of the availability of original invoice from which the value of scheduled goods can be ascertained. Hence, the statutory provision 2G mandated that in case of receipt of goods otherwise than by way of sale, the incidence of entry tax shall be on the sale value, not the receipt value. Hence, the contention of the learned advocate in the written submission by invoking section 2J on the fact and circumstance of the case is not permissible, carries no legal force. Perusal of the OVR case record revealed that in course of tax audit, the audit was a team on random basis of selected 19 items of business goods dealt in the dealer company and compared the receipt value on branch transfer with the corresponding sale value such items and found discrepancy ranging from 28.16%, that is lowest, and highest is 356.55% highest. For better appreciation fact, the receipt value and the sale value of such item is stated in a tabular form. Your lordship may kindly compare the purchase value and the stock transfer note value, your lordship, and the sale value, and what is the difference? The difference has been gone to 356%, your lordship. And your lordship, the stock transfer note, your lordship, based on stock transfer note, they will transfer the value and that will be taxed at the rate of stock transfer, your lordship. How
It
can be your lordship?
will appear the absurd the question now I put you. There is one question is called the inflationary effects on the price of the goods.
Your lordship.
Right. You are just showing us the higher right. When does it fall? Do you give it any concession? When the price suddenly falls, do you provide the concession or the compensations to the dealer? You don't give.
Your lordship.
So they're running the business risk, and some certain thing we cannot project what will happen to the goods. So when the entry tax is concerned, I think these are not very relevant at all. That is why all the time I was emphasizing on the point in time, which will be the point in a time for purpose of this exigency of tax. Otherwise, so many things may happen. Even are not sold, there is a declared obsolete.
What my respectful submission before your lordship is that
this is very definitely it shows that how the government is losing some from the potential price.
That is that I may not write, your lordship. at this point, Your Lordship, actually what happened, Your Lordship, and with Mr. Das, Mr. Das has submitted that he has submitted all the stock transfer, all the excise.
Because he's concerned with the stock transfer.
Excise invoices and all the details, but he has not submitted. So once excise, even admitting for sake of argument, Your Lordship, the petitioners in all these cases have disclosed the stock transfer, the value of the stock transfer. Even, Your Lordship, Section 2J, so far as the first part is concerned, the first part says that the value from original invoice, ascertained from original invoice, plus, Your Lordship, so and so, paid VAT is. But in stock transfer, no value, Your Lordship. Once, even for a member, in 100, the value has been reduced. In 100, it can be reduced because there is no, it is self-same transaction, Your Lordship. There is no sale or purchase, Your Lordship. And in other hand, it has not been added. All these, what has been added so far as the Section 2J first lien is concerned, that has not been added. If those could have been added in the stock transfer note, then might be something else, because all these are self-assessment. Your Lordship, they have to file the return by disclosing the correct value. So why the stock transfer note value has not been accepted? These are the scenario, Your Lordship. But that is then, Your Lordship, it has been stated that the sale price means the sale price at the entry of the goods. What I understood, Your Lordship. Exactly. Because entry point, the taxable event is very important. On the taxable event on entry, the sale price cannot be at a latter stage.
No.
The sale price, what is the solution on that? What I understood the intention of legislature in inserting this proviso and this particular third lien. This is the intention of legislature, that Your Lordship, for a moment, what is the difference between the purchase value and sale value as per 2J? Your Lordship, purchase value, at what point this purchase has been made? So, purchase value includes all these things, Your Lordship, charges, all these charges have been included in the purchase value. Yes. So only Your Lordship, only profit ratio, because except profit, all these have been added as per Section 2J of the purchase value, which has not been challenged. So my respectful submission before Your Lordship is that the entry, it is equivalent. If Your Lordship can interpret, it is equivalent to purchase value. Because at the time of the entry of goods, purchase has been made. Sale price. That is the sale price of the open market, Your Lordship, at the time of entry. So that is the intention of legislature, because it cannot be done by entry 52. Exactly what's going on at the entry point. It means, Your Lordship, in all these cases, the best judgment assessment has been done because they have disclosed it. Even they have disclosed by adding all these additions, what should have been added in Section 2J first lien. If it could have been given, then they almost transfer seats to the revenue to disprove that. My Lord Senior Das has argued that I have given everything. That the excise, even Your Lordship, for a moment, I accept. Your Lordship, it is my respectful submission before Your Lordship. Excise note. Why we are not accepting the STN, stock transfer note? Because transaction in between two parties. But excise note is a transaction. So the value is there. If the value, excise note value, including all these values, whatever been given at 2J, that can be accepted. Mr. Das has argued that he has submitted everything, but my record, and so far as all these judges have stated that nothing has been submitted except that stock transfer note. So my submission before Your Lordship, this is the intention of legislature, that everything has to be done at the.
So how this form F has been
just out of 2 to 3. Your Lordship, so far as the stock transfer note, Your Lordship, is concerned, Your Lordship may kindly look into page 10.
Page
10, Your Lordship, of my note, paragraph 9. But it's only submitted that in the instant case as the scheduled goods have been received otherwise than by way of purchase and transfer of stock, entry tax is to be levied on the prevailing market price of the goods so received. As the petitioner is trading of the said good every day, he is well aware of the prevailing market price of the goods at the time of entry into local area. As the petitioner failed to read a rules in this regard, entry tax has been levied on base judgment assessment by the assessing officer. Thus, entry tax has been duly levied as per the taxable event, as per the nature of levy, purchase value as envisaged in section 3 read as proviso to section 2. It is only submitted that legislature has not encroached upon the field under 8054 by providing for levy of tax on prevailing market price of the goods in the proviso to section 2J of the OET Act. The prevailing market price of the goods on the date of entry of the goods into the local area has relevance to the price of goods when the tax becomes chargeable irrespective of the fact that there may be a subsequent rise or fall in price of goods on the date when goods entered into the local area are actually shown. Thus, prevailing market price of the good on entry into the local area is not the sale price of good. The entry of goods and sale of goods happen on different occasion and different date. The goods entered into the local area may not be sold also for various reasons and on business wisdom of the dealer. Thus, the legislature has not provided for levy of tax on price of goods sold. Without reference to anything to the contrary, what provision, what I have already submitted that the petitioner cannot pick and choose provision. The petitioner cannot submit that they will accept the purchase value as envisaged in section 2J and not provisions in the proviso thereto. Alternatively, are doing without considering it, it is only submitted if the petition contains that stock transfer note is the original invoice or bill, then he should be complied with the provisions thereto under section 2G in its entirety. He should have been added insurance charges, excise duties, countervailing charges, value-added tax, transportation charges, credit charges, and all other incidental purchase values shall be the value of goods as ascertained from the original invoice or bill or includes aforestated incidental charges. The petitioner having not done so cannot be permitted to seek relief in both the ways. Now, Your Lordship, the petitioner has contended that he should have been assessed as per the value of good mentioned in the stock transfer invoice. It is only submitted that the term invoice as envisaged in section 2J would be interpreted as bill, which is a document of transfer of title to goods, and the term invoice would similarly be the document of sale between two or more parties. The stock transfer note cannot be denoted as invoice because stock transfer note is used when goods move from one destination to another in relation to the same person. The value of goods in a stock transfer note can be minimized or maximized, taking into consideration other aspects such as insurance, damage, or therefore cannot be represented as the value of good. It just indicates unilateral declaration of the value to cover the transaction under tariffs for insurance coverage for swing transfer in case of damage of goods. The stock transfer note is not an invoice, and the stock transfer note represents movement of goods. In order to be represented as invoice, there must be a divestment of title over. Your Lordship may kindly next paragraph clarify the provision content, and Your Lordship, it is only submitted that petitioner appears to have misconstrued the provisions of statute proviso section 2J or poetic further explain the measure of tax in event scheduled goods are not acquired or obtained otherwise than by purchase. The purchase value for the purpose of levy of entry tax scheduled goods acquired or obtained is the value of the price at which scheduled goods of like kind or quality is sold and is capable of being sold in open market. See, the taxing event is entry into the local, meaning that to a point, so all the value addition to that point will be taxed. This is what the legislature intends to convey by providing the levy of tax in the prevailing market price, Your Lordship. Your Lordship, and this prevailing market price has been defined, the definition has been brought from section 234 of the Odisha Value Added Tax Act, Your Lordship. And the section 236 also published definition is there, and as per 2Q of the definition of Odisha Anti-Tax Act, we have borrowed those definitions from, we can borrow those definitions from Odisha Value Added Tax Act. Now, Your Lordship, another question also formulated that my learning seniors have argued one point, Your Lordship, that state has also not formulated any rule. Your Lordship, my learning senior have argued that no rule is there, Your Lordship. For that, Your Lordship, may kindly turn to page 17, paragraph 11.5, Your Lordship.
Yes.
The state has also not formulated any rule providing for measure of tax in terms of section 3 reduced section 2J, which give rise to exercise on channelized and unguided power by the taxing authority, and the same constitutes sufficient ground to strike down the provision, being illegal and unconstitutional. It is only submitted that when the quantification of measure of tax is permissible and possible and harmonious reading of section 3 and section 2J, in absence of rule any which would not entail declaration of provision to clause on. It is further submitted that petitioner participated in the assessment proceeding, and when the demand is raised in order to provide the constitutional validity has been challenged, Your Lordship. Now, Your Lordship, so far as the question Your Lordship has already asked me, so far as that 6A, Your Lordship, why this has been allowed under section 6A of the CST Act and why it cannot be allowed under OET Act, Your Lordship. Your Lordship, may kindly turn to page 20. Paragraph 11 to 10, Your Lordship, all other paragraphs are factual, Your Lordship. That the petitioner has taken the abandonment that assessing authority having accepted the stock transfer note under section 6A of the central along with the prescribed declaration for the impugned period cannot deny the purchase value as per the stock transfer note under Entity Tax Act. It is only submitted Central Sales Tax Act and Odisha operate in different spheres. Central Sales Tax Act is an act to formulate principles for determining when a sale or purchase of goods take place in course of interstate trade or commerce, or outside the state or in course of import into export from India, to provide for the levy, collection and distribution of taxes on sale of goods in course of interstate trade, commerce, and to declare certain goods to be special importance in interstate trade or commerce, or specify the restriction condition to which state law imposing taxes on the sale or purchase of such goods shall be subject. Section 3 of the Act formulate the principle for determining when a sale or purchase of goods take place in course of interstate trade or commerce. Section 5 thereof, Your Lordship, it is all these sections are CSTR. Section 5 thereof determines the principle when a sale or purchase of goods take place in the course of export or import. Section 6 of the Act determines the liability to tax on interstate sales. Section 6A deals with the discharge of burden of proof. Section 6A that the taxpayer has to adduce evidence to that effect that movement of goods to outside the state otherwise than by way of sale by producing document as well as prescribed declaration substantiated claim. The Section 6A CST Act provides for exemption from liability by providing that movement of goods to outside the is otherwise by way of sale. Now, the petitioner proves and disputes that the movement of goods to outside the state has occasioned otherwise than by way of sale. It is not the case that ST and stock transfer note is accepted or rejected under section 6A of the Central Sales Tax Act. The taxpayer adduces sufficient evidence to show the movement of goods to outside the state as occasioned otherwise than by way of sale to avail exemption under section 6 of CST Act, and liability has been fastened under section 6A of Central Sales Tax Act on movement of goods to outside the state by way of sale in course of interstate trade or commerce. Attempt is being made to confuse Your Lordship, such pleadings should not issue in the benefit of the petitioner. Section 6A is entitled exemption from liability on movement of goods from outside the state on evidence, whereas section 3 of envisages liability of tax on entry of goods in local area. Cannot be imported and interpreted the provision of another act, Your Lordship. Now, Your Lordship, again, the challenge, Your Lordship, so far as the 14 and 19(1)(g), Your Lordship, also that is not in the challenge, but I have quoted at page 15, paragraph 15, Your Lordship, how it is not violative of section article 14 and 19(1)(g), Your Lordship. Now, Your Lordship, my respectful submission before Your Lordship is that the intention of legislature so far as this proviso is concerned is very clear, Your Lordship. It is the value at the time of entry point, Your Lordship. Not the intention that is the value of sale value is to be borrowed by when this good has been sold, Your Lordship. And Your Lordship, the value, everything is at the point of entry. Even Your Lordship, for a moment, or not accepting otherwise, Your Lordship, for a moment, Your Lordship, even the stock transfer, it is the self-assessment statute, Your Lordship, in all these assessments, they have to file it on by disclosing the value of the goods, Your Lordship. And in all these cases, your lordship, the value of the goods have been, your lordship, in all the value of the goods is as per the stock transfer note. Even for a moment, your lordship, stock transfer note value can be accepted, your lordship, but it has to be, all these additions have to be made and it has to be disclosed by the petitioner himself. And the department, the revenue, is only to confirm that, your lordship, basing on the evidences produced. Even for a moment, your lordship, so far as that excise value, we are not denying, department revenue is not denying to accept. Why it is ascertainable, it is not denying, your lordship. It is not, stock transfer note cannot be accepted, what the revenues contains on, your lordship. Now, your lordship, another part, your lordship, I have your lordship, many judgments, your lordship, my lord and seniors have submitted many judgments. And I have tried to make an analysis of the judgments, how the judgments are applicable, how the judgments are applicable and not applicable. And then, your lordship, I will try to go and to submit some of the judgments, your lordship, on my side.
You supplied the copy.
Your lordship, okay. Submission copy. Your lordship, the past judgment, my lord and senior judgment. Yes. Your lordship, the past judgment, my lord and senior has submitted the state of Karnataka versus HON'BLE Corporation. Your lordship, whatever my lord and senior Mr. Sahu has submitted that booklet, your lordship, on that, those judgments I have that it is only submitted that in case of state of Karnataka versus HON'BLE Corporation, the Honorable Apex Court has observed that there is a specific guideline in the charging section itself for taking into account the price according to which tax should be computed. While observing so, Honorable Apex Court considered two scenarios. First is the scenario of purchase, in relation to which the Honorable Court observed as follows. When the goods are brought within the local area, they have a certain price. The price may be the price which the importer of the goods has paid before bringing the goods within the local area. The second is the scenario of entry of goods manufactured in another local area, in relation to which Honorable Court observed as follows. Even if the dealer is the manufacturer of goods at a place outside the local area and bring the goods within the local area, he must have determined the price of the goods. Therefore, the dealer has some specific price of the scheduled goods which are being brought within the local area at the time of entry into the local area. And the entry in the taxable bill, that will be the price which alone can be taken into account for computing the tax ad valorem. Your lordship, this ad valorem means, your lordship, all this.
The value of the goods.
Yes. So this observation of the Honorable Court needs to be interpreted in the context in which it is rendered. The petitioner being received several goods by way of stock transport and false entry of the said goods is liable to pay tax on the purchase value as explained in the proviso 2 of section 2J. The aforesaid judgment of Honorable Apex Court therefore cannot endure the benefit of the petitioner. Now, your lordship, CST MP versus Gujarat Steel Tubes. Your lordship, petitioner has cited the judgment of Honorable High Court of Madhya Pradesh in case of Commission of Sales Tax MP versus Gujarat Steel Tube India. It is to be mentioned here that the referred judgment was passed in a different context. Therefore, it is not applicable in the referred case. Empty tax was levied by the assessing authority on the sale price of the goods of manufacturing unit. An assessment order was passed assessing sale price as market value order, and assessing authority was negated by the court. The observation is that the sale price fetchable after entry is to be higher than the value of entry. However, in case of OETR, levy of entry tax has no relation with the price of goods sold on entry into the local area, which happens as a date subsequent to the date of entry of the goods. It only prescribes levy of entry tax on the prevailing market price at the point of entry of goods under the proviso to section 2J of OETR. Your lordship, the next of mine, on all these cases, your lordship, I just want to establish, your lordship.
Whether Mr. Mishra, that because we have referred to the 3 incidences,
your lordship,
whether even in the incidence number 1 and 2, this principle will apply. whether the assessing authority go for ascertaining what is the real price in the market.
Your Lordship, assessment assessment.
That is not the intention even of the proviso that is under challenge. That is why. That is only when it is not ascertainable at the point of entry, then the question, all this question will come.
Your Lordship, that is the intention. Your Lordship, ascertainable, Your Lordship, what the respectful submission before Your Lordship is that not ascertainable in absence of original invoice, because in all these cases, the intention of legislature is that not to accept that stock transfer note. Your Lordship, because in stock transfer note cannot be as invoice.
Yes.
It cannot be tax invoice.
Nobody is claiming that that is invoice.
Your Lordship, Your Lordship, my learned seniors have argued that that is invoice and that is the value.
For the time being, that should be accepted as the price.
Your Lordship.
That is what. This is an invoice only for a very limited purpose.
Your Lordship.
But in character, it is not an invoice. Invoice with deals and other things is well defined in text.
Your Lordship.
That you could proceed from that point of that.
Your Lordship.
You have objected that the STN cannot be treated as an invoice.
Your Lordship.
All right.
Your Lordship, my sole argument, my entire argument, Your Lordship, that cannot be accepted because of value, because that there is no any 2 persons and there is no transfer in 2 persons, Your Lordship. So that is self to self. So I can reduce, I can enhance due to different reasons, Your Lordship. But that isn't. Only stock transfer note cannot be accepted, Your Lordship.
According to you, it cannot be any document of dependable price.
Your Lordship, it has to be supportive. Any supportive. Suppose that excise note.
We have taken note of
that excise note, everything, if that can support, then that can be accepted. Now, Your Lordship, suppose the third judgment, Your Lordship, CST versus Hindustan Steel Gwalior. Your Lordship, MP Gujarat Sales Tube, Your Lordship.
Yes, yes.
The High Court of Madhya Pradesh, Your Lordship, that this has been completed. Hindustan Steel Gwalior, Your Lordship, that the petitioner has referred to the judgment of Honorable Madhya Pradesh Jabalpur. The Commission of Sales Tax versus Hindustan Steel Limited, in the said judgment, it was observed by the Honorable Court that entry tax on the entry of goods not in its sale, if sale price is taken as the basis, then it will remain entry tax on entry of goods because the sale depends upon the time when the goods. Your Lordship, not remain entry tax on entry of goods because the sale depends upon the time when the goods are sold. Your Lordship, pause for a moment. Your Lordship, for this reason, in Orissa Anti-Tax Act, the language is that similar kind of good. Your Lordship, not this good. Your Lordship, all the statute, the same good is there. The statute, the same good is there. But in Orissa Act is that the similar kind of good, similar kind, similar quality. But that reason it has been inserted by clarifying that if the entry point, the selling price of the entry point. And what I understand, Your Lordship, that there may not be any difference between the purchase value as per 2J and the sale value as per the proviso at the entry point, Your Lordship. And now, Your Lordship, it is to be mentioned here that cited judgment is not applicable of fact and circumstance because intent behind the legislation of Section 2J of OET Act has never been point of sale. Neither there is cited link of levy of entry tax with sale point. The sole purpose of legislation is to levy tax, entry tax on point of the entry of goods on local area from outside the local area. But in certain cases, when the purchase price is not ascertainable, when goods are brought into the local area, otherwise than by way of purchase, the prevailing market price of the goods are considered as the yardstick for levy of entry tax.
I think all the decisions are on the same tune.
Your Lordship.
So you can skip over, we'll read it.
Your Lordship.
Come to the Burma shell, because Burma shell is a little different words.
Your Lordship. Burma shell. Your Lordship.
Yes.
And Your Lordship, now Your Lordship, now Your Lordship, I will be permitted, my Lawrence seniors, all the seniors have read down, Your Lordship, that Voltas Limited. Voltas Limited case, Your Lordship. Yeah, let's say I may be permitted to place that judgment because that judgment is very vital on the language of the statute Karnataka High Court. And let's say, but just identical. Just it is identical. Rather, if the language is worse than us, that's why I'm saying so, because there the language is such goods. You know, let's say, my kindly come to paragraph page 285.
Page?
What are the definition? Page 285.
There are 7.
Your Lordship. The question, Your Lordship, to consider the contention also, we find it is necessary to closely look into the charging section. Section 3 of the Act, the same provision, Section 3 of the Act, read thus. There shall be levied and collected a tax on entry of any goods specified in the first schedule into a local area for consumption, use, or sale therein, at such rate not exceeding 5% of the value of goods as may be specified respectively by the state government notification. Different may be specified different clauses of different local areas. Your Lordship, here it is 5 only percentage.
Yes.
The definition of value of goods as defined under section 28A of the Act reads thus. Value of goods shall mean the purchase value of such goods. That is to say, the purchase price at which the dealer has purchased the goods, inclusive of charges borne by him as cost of transportation, packing, forwarding, handling charges, commission, insurance, taxes, duties, and the like. Or, if such goods have not been purchased by him, the prevailing market price of such goods in the local area. Our statute is rather, what I understood is rather more Your Lordship welcome this. Because in our statute, the language is that similar kind, Your Lordship, again I may withdraw Your Lordship's attention, like kind or quality is sold or being sold in the open market. Your Lordship, here, prevailing market price of such goods in the local area, such goods in the local area. So now what the Honorable Karnataka High Court has decided, Your Lordship may kindly, Your Lordship, Section 3 of the Act is a charging section, Your Lordship may continue, which provides for levy of entry tax on any goods specified in the first schedule, which enters the local area for consumption, use, or sale therein at such rate not exceeding 5% of the value of the goods, as may be specified only retrospectively, prospectively by the state government by notification, etc. The same section also provides that rate may be followed by issue different notification in respect of different goods, different class of goods, or different local area. The definition of the value of goods are set out in section 28A referred to the above consists two parts. The first part relates to determination of the value of the goods purchased by a dealer which is brought into the local area. The other part relates to the goods which has not been purchased by a dealer which is brought into the local area. So far as the goods purchased by the dealer is concerned, section 28A of the Act provides that the value of the goods purchased should mean the purchase value of the said goods, that the purchase price at such which a dealer has purchased the goods is inclusive charges borne by him as cost of transportation, packing, forwarding, handling charges, commission, insurance, taxation, so and so have not been purchased by the dealer. And the like, so far as the goods which have not been purchased by the dealer according to section 28A, the entry tax payable will be on the basis of prevailing market price of such goods in the local area. Therefore, when section 28A of the Act provides for determination of the value of the goods which enters in the local area, otherwise than by way of purchase, the tax is made payable on the basis of the said value. In our considered view, the entry tax that would be payable on the goods that enters the local area at the instance of a person who is not purchaser of the goods could be only on the basis of market price with the goods in the local area, when the language employed the section which provide determination of the value of the goods is clear, unambiguous, and does not lead to any absurdity. It is not permissible of the court to interpret the said in any. The court have to interpret the section as it reads. Therefore, when section 3 of confers the power on the entry as noticed by us and provides for determining the value of the goods, therefore, we do not find any merit in the argument of Sikumar. The assessing officer was required to tax only on the date of their entry into the local area. Your Lordship, what the worst condition has been cured by the Honorable Karnataka High Court, that such goods. So therefore, we do not find any merit. So and so, it is true that it is not permissible to the assessing officer to levy anti-tax on the basis of the sale price of the goods which enter into the local area. The decision of the case, State of Karnataka Hansa Corporation strongly relied upon Sri Kumar. No doubt supports its contention that even if the dealer's manufacture of good is placed outside the local area and brings the goods within local area, since at the time of entry of the goods into the local area, the dealer would have determined the price of the goods, he is required to pay the tax based on the price of the good. In this connection, it is useful to refer the observation made by the Supreme Court at paragraph 38 of the judgment, which reads as hereunder. The contention overlooked the specific guideline to be found in a charging section itself. The taxing event is the entry of the scheduled goods into the local area. The tax becomes payable on the entry of the scheduled goods in the local area. Therefore, the price of the scheduled goods at the time of entry paid by the dealer, who is importer of goods within the scheduled area, would be the ad valorem price on the basis of which tax would be computed. No subsequent rise or fall in the price has any relevance to the computation of tax. The charging section says the tax shall be levied and collected on the entry of the scheduled goods in a local area at specified percentage not exceeding 2% ad valorem. Therefore, the price of the scheduled goods at the time when the tax becomes chargeable, irrespective of the fact that it will be computed at later date, when the dealer submits his return as required by other provision, would be the price of computation, and there is no ambiguity of any vagueness in this gap. There is thus specific guideline in the charging section itself for there, taking into account the price according to which this approach overlooks specific. Therefore, the dealer has some specific price of the scheduled goods that are being brought.
That the issue was there whether the entry tax was determined on the basis of the sale price.
Your Lordship.
And the court found that was not so determined. Therefore, there was no intervention.
Your Lordship.
That is the thing.
Your Lordship, here what happened, as per that 2A, the subsequent price has not been accepted by the court. But Your Lordship, the stock transfer note has not been accepted. On the stock transfer note, and measurement assessment has been done by estimating, by making the addition on estimate basis. And in our making STRs, Your Lordship, the same thing has been done by the assessing officers by estimating so far as this percentage, Your Lordship, has enhanced the value, Your Lordship. So, what my respectful submission before Your Lordship is that but it is the assessment because Your Lordship stock transfer note has been accepted and even the petitioners have not disclosed in its return by adding all these values.
A simple question.
Your Lordship.
How the best judgment principle can be applied when the judgment itself says that we exclude sale price?
Let's say exclude sale price at a later stage. Here in our case.
No, that is what.
Yes.
The sale price at this point of time is a relevant thing. But in the same price, as you are started arguing at that point of time, it may increase, decrease. Those retrospectivity or prospectivity doesn't apply in the principles of the entry tax. It is there only when the entry is the physical point of tax. This is the site of taxation, and that also the time of at the point, only the entry point. And the price is completely different concept from the price at the selling point. Right? Price at the entry point and price at the selling point are two different concepts. That is none of the apprehension that has been projected before us. That when you say that price is the selling point is considered.
Selling price?
Selling point may be considered, and that you are now bringing the best judgment methods.
Not at all. I have never said that the price at a later stage from my side.
No, that you have clarified in the note also.
Why you have done? Because Panakasai on the facing of their or on the face of their submission, it is not satisfied. Why it is not satisfied, Your Lordship? Because even for a moment, Your Lordship, stock transfer note is accepted. Value has not, all these additions have not been made. At all, Your Lordship, that can be accepted. And all these values, transportation charges, so and so, taxes, insurance charges, all these And this is the petitioner instead of discussing seems
Clear, that is clear. Okay. Come to an end now because we do not have time.
now.
We have completed.
I'll take another half an hour. I maybe.
So this will be difficult. Then we have to go. Where is Mr. Sahu? He's not here.
Actually, he was here. He's on his legs before another court. He was here.
To give any rejoinder?
Yes, Your Lordship.
Then we make it partial now. Again, it will go through this. I think fifth can be done.
You Lordship, 4th, 5th, 11th, 12th, 13. You Lordship, these 5 days, many cases have been fixed, and I am to argue all these cases. Your Lordship also 5th, Your Lordship has fixed that matter at 3 p.m.
Right. Tomorrow cannot go
14th, Your Lordship.
14th.
If as Your Lordship pleases, but all these came. 14th at 2 p.m.
Mr.
I mean, pardon me, Lord, tax section 51, 52, 54, and 55. I'm not filing the written note, small written note. And that judgment and I've already filed earlier dates.
Yes. But Mr. Council appealing to the petitioner in STREV number
51, 52, 53, 51, 55.
I'm sorry, bro, sir. No, that we're fixing the date 14th now. Minus. Last survey, the matter which at best your case number is 2016. 50 up to 16, madam. 50.
Because I'm submitting today note of argument in STREV number 26, 27, and 28 of 2019.
All it is Jacob is no.
This here STREV.
And also Mr. Mohanty. Mr. Mohanty, your matter is?
It is 73. There I have paid the entry tax on the sales invoice price.
Mr. Ashok Kumar Mohanty, when it's considered, does in STREV 73 of 2014.
73 of 2014.
And this too, so they are. And Mr. Sunil Mishra, and it's Training Council, Commercial Tax, GST, has appeared for the revenue in all the matters and made the substantive submission. But he asked for further accommodation for completing his submission. Questions allowed that the matter be listed on Wednesday date as part for continuation of hearing. The judgment and the judge is analysis just the oldest the analysis of citation, everything is filed by the council, certain section by certain section taken on the record. Mr. Kaur, have you just filed the complete note of submission?
By next date, I'll file my written note. I'll mention the item numbers in which I'm appearing and I'll file that.
Just, I think it should be better if you can, we have a consolidated list. Between yourself, if you discuss and find a consolidated who is appearing, then there cannot be any mistake regarding the appearance. Because in some matter, Mr. Satapathy is also appearing. You are appearing on 51, 52, and 53.
And my lord, WPC number 1804 of 15.
Better let all the officers give separately the list of cases which they are appearing.
Exactly.
So that will be better for your lordship.
Yes, that is why.
By next date, we'll give it.
Yes.
By next
We are taking these things on record. You filed your note. Is this next matter called? Just 5 minutes. No other matters can be taken up today.
Only item 29, my chances are becoming very bleak. Let's say it's a hard matter. Let it be tomorrow. At 2 o'clock because it was
2 o'clock we cannot issue. Just fix on tomorrow. Right. Tomorrow.
tomorrow morning at
Just mention. Section is give the dates, please make the date. Item
23, please.
Item 30, my lord. Cases your lordship, we are not getting, my lord. Item 30, real cases scheme, your lordship. That is
give you list tomorrow. We'll try to take up the matter.
item 30 is
in item 30, we are there for me. Yes, ma'am.
Alright, just to check.
In item 30, may I pay your lordship fix it to next week? Why I am paying, my lord, that your lordship's judgment has not been uploaded till now.
Alright, this is will fix on 4th September.
Yes, ma'am. So by that, yes, I request that by that time that
judgment will be done.
So that I will verify that I will go through the judgment and those cases are covered under that. I can say that. I may fix your lordship. You are not sure item. Yes, 40 particular same 16 mailer. And then serial system the same matter. Arrest matter. That will 16 also said.
Just a minute, don't mention the matter. Give the date of reference. You will try to.
Item 20 matter. Yesterday this writ appeal was there. Today listed at item 20. Now taken it tomorrow.
Or you will try 20. Just one public interest litigation I am taking up. It is this.
May I be permitted to mention, my lord? Item 50, lordship specifically posted today, which is the rule has been challenged.
Item 23, please.
This matter, there is a matter called out. Please allow me to just pass.
Your lordship, item 30 may fix, my lord, 2 p.m. or your lordship is fixed. On 4th, it is 2 p.m. Item 30. That is actually my topic number of
4th of September. Just wait till then.
My lord, item.
This matter, Mr. who is appearing? Mr.
Minor item 30. Item 23. Yes. Very urgent matter. Vacation of stay also.
23. Taking up one matter. Please wait 1 minute. Yes.
You are appearing, Mr. Putti is appearing.
You are appearing in this matter?
My lord.
I think you have gone to the Registrar General's note.
Yes, ma'am.
There are frivolous litigation coming into the court. because government is not disposing of the representations. Government is not disposing of the notice under section 81 substantively. Even acknowledgement is not given to the person is aggrieved by any action of the government or the public servant. So you are issuing notice.
I'll take instruction on that part.
It will come on the 13th of September. Stop. It's in the note of the Register General, the Register Judicial, dated 25/8/2023. Stop. Consider the public interest in for the interest of the substantive justice. This reference has been registered as the public interest litigation. Issue notice since Mr. M.K. Kumpial, an additional government advocate, appears for the opposite parties number 1 and 2.
You are appearing.
And Mr. P.K. Pari. Council, 1 and 2, just this 1 and 2, 1 is within bracket. Government of Orissa, represented by the Chief Secretary, General Administration and Public Grievances. 2. General Administration and Public Grievances Secretary, General Administration and Public Grievances, Government of Orissa. The opposite party number 3, and Mr. P.K. Pari, Deputy Solicitor General of India, appears for the Union of India. The opposite party number 3, the Union of India, by the Secretary and Department of Administration, and this will be the Ministry of Administrative Reforms and General Grievances, and we have notice. Notice is made returnable on 13th September 2023. We direct the opposite parties to file their response by the next date. Yes. By 13th September, file your response. There is no factual aspects, only your intention should be reflected. Yes.
Item 11 may taken up.
My lord is fixing 13th September.
13th September. Yes.
May I be permitted to mention, my lord, I'm in the Bhajpal mode. Is a year LRC specifically posted item 50. But today, my lord, this is a promotion has been started. This is LRC take up my lord, any day, tomorrow or next week, my lord.
All that we will be trying, you give the case number, we will be trying expeditious listing of the matter, but all matters you cannot list in this fashion.
Item 50.
31. 31, let the matter be listed sometime next month. Entry model is passed earlier, shall continue till the next stage. Yes. The matter will be listed on 21st of September 2023.
Item
Item 34, my lord, the pleadings is already complete and short date may be fixed.
Short date means is the 21st September.
It's the PIL matter by
14.
Item 21, my lords, relating to the cooperative bank. The other side is also present. If my lords may have it tomorrow, I'll take just 5 minutes because we need the direction from my lords.
Tomorrow I have the personal meeting. Let it day after tomorrow.
Day after tomorrow is possible. Day after tomorrow is not working day.
Would my lords take it up at a particular time? Because it's a Friday, 12:30 if it's...
5th of September.
That item 12, your lordship.
Item 21, 5th of September.
Item 12.
Item 9, they are. Item 9, they are.
So which one we have?
In item 21, the IA, 1112228. There's an IA and writ petition. Writ petition.
21, if it is adjourned by a judicial order, if you want to be extended.
My lord,
Item 21, which my landlord is making a mention. If it is extended by adjourned by a order.
Interim order process.
I'm sorry,
Shall continue till that. Okay. So
Item 12, your lordship. Sorry to requisition is filed in the earlier order. Kindly next week requisition will file by the next week, my lord.
all right.
My lord, item 20, my lord, batch case, my lord. Item 30 in the batch case, my lord, page 19.
No, they will file it. Yes.
Item 13,
So
batch
Whenever
case,
you
my
file
lord.
the requisites, order is not necessary, you file.
My lord, my lord.
Item 13, batch case, my lord. My case is not equal to the case which were listed, my lord. In this case, my lord, the rehabilitation denied on the ground that his mother is in life. To be, it is not Malavananda case, my lord. His case was considered under oath.
It come on 4th. We have fixed the matter on 4th.
But it is different from the subject.
Only on that day we will segregate the matter.
Item 20, my contempt of petition has been filed. Case matter may be taken up tomorrow.
Already we have passed order.
Item 14, your lordship. Lordship, we have for the responding number 1 time is required for filing of the counter. Any specific?
Time will be granted, just collect it.
Yes. Yes, sir.
Item, I am on VC, I may be permitted. Item number 34, it is a matter where a person has rendered more than 30 years of service, but he has not been regularized. That ad hoc period was not regularized. And Umadevi case is squarely applicable, and basing upon that, he has to be considered. He was appointed as a clerk in the forest department and he continued. And for 28 years, he has rendered now without pension because of the order passed by the learned single judge. That period which he has given an order that cannot be regularized. The writ appeal is pending. We need to lordship.
The Umadevi's principle will be applicable in a case of the regularization of the ad hoc employees.
My lord, here it is a question that this person was an irregular recruit. The recruitment, he had undergone the recruitment procedure in the year 84, sorry. And subsequently, he continued under the forest department. And in between, my lords, he had approached the tribunal. The tribunal had passed an order that when a regular selection.
Yes.
With the candidates and then
regarding the selection process, Umadevi doesn't apply. Paragraph 53 of the Umadevi, you can vote.
My lords, in a regular sanctioned post, if a person has been appointed and he continues for a period of more than 28 to 30 years, and the order of stay that for 10 years continuous stay, if it is, then there is a change of situation. The government as a one-time measure will be given the opportunity to regularize the persons. So number of persons have been regularized. But so far as this petitioner is concerned, this case was not taken for regularization.
We took a point that we will be fixing the matter shortly.
Item 34. Item 34.
All right, it will come on 14th of September. Come on that day.
Much obliged.
Mental tension, my lord.
That is the problem. He is not showing the bona fide. A person really has some remorse, should approach that very court. He passed that. And 7/8 is a date. We all remember why the 7/8 was actually chosen for filing this application. You don't have the bona fide. So why we should modify the orders? Even now also you are showing not bona fide. You are the shopping the bench that you knew the 7/8 filing means it will not be taken by that bench. One of the judge of that bench will retire. So this is not bona fide. You have no remorse at all. Why you should modify the order?
Young lord features is there, my lord. The reason I am submitting before lordship and
maybe young, but he is not juvenile. He must understand.
Yeah, that is correct. Not juvenile.
We rely on just without opening eyes. Court.
Yeah, but lordship, that I cannot comment on that. Lordship absolutely correct.
What actually they have also filed the affidavit.
Para 4, my lord. Page 3.
Come to para 4,
my lord. You should have filed prior to that. That is your lordship. What's your lordship's opinion?
We will not modify this order. Whatever you want to say before the disciplinary committee of the Bar Council of India. Not before us anymore. Yeah. I will not modify this order.
My young counsel and
no, he is not like an inexperienced counsel. Just show this order, their report. There he also took time for this. I filed the show cause after 15 days.
That is the reason.
The council, we all have come from that side.
Yes, I
know the chair of the council. He should be bold enough that if I committed a mistake, go before the judge says, sorry, I committed the mistake. He's not done that.
That should be.
He's not done that.
That should be, madam.
Sorry that we will not going.
I say, madam, on behalf of the bar, kindly consider.
No. There is no question. We have to ultimately run the court. We cannot sacrifice the decorum and the sanctity of the court proceeding.
Hey, what happened, my lord? Briefly transfer time and again. That is the reason. Just slip up long, one transfer, then take back the brief. Then
I am not referring for a single moment of the conduct on the particular day. I am referring his conduct after the order was passed. Someone is very sincere.
That should
be. No, sorry. File better affidavit. We'll consider it, but not today. Let the matter be listed on 1st of September 2023. So the grounds assigned in this petition for recalling, modifying the order dated 23/6/2023 are not only inadequate, are unacceptable. The request of Mr.
I am Mr. A.K. Budhia. I am not A.K.
Budhia and Council. Let the matter be listed on such and such date. We are postponing the final orders till then. Now you decide what you will do.
The proceeding may kindly be kept in the back till the next date.
No, sorry. Bar Council proceeding, nothing would happen. You go there and
he is suffering, my lord. Every Sunday he is calling and sitting there for 11 to 3. That is suffering, my lord. And now he is
suffering for any fault of the court.
My lord? No.
Then just wait.
I pay, my lord, so that it is easy for him to
think over. Court has expressed that the grounds he has assigned is unacceptable to the court. Now what step you will take, you think yourself. Yes, Mr.
I think kept in advance, my lord. I pray for a short period.
No.
Or a short date may kindly fix, my lord.
I am very liberal in granting adjournment of the thing in appropriate cases, not in all cases. Sorry, Mr. Budhia. Yes.
Yeah, that is the reason I am praying, my lord.
Last turn to page 15 in the open order, by.
Honorable Single Judge is directed to give him promotion on the date when his juniors has been promoted. That we have denied him promotion and his case was kept in seal cover because of the vigilance case was pending against him. So I have given that copy of the judgment.
Yes.
We have relied upon our circulars and also the judgment in that case, Janaki Raman case,
is
relying that those judgments, the lordship has passed that order that they cannot get from regular promotion.
But here the direction of the promotion has been granted, the judgment para 12.
Para in that division bench.
No division bench.
No, that after exoneration.
No.
Yes.
No, after exoneration. Come to the para 12.
Yes, madam. Set aside, my last.
Oh, okay. That's
set aside.
All right. Heard Mr. M.K. Kuntia. Are you who is appearing?
Madam.
Accept notice.
Madam.
And he has accepted notice and he has also filed an affidavit to that.
So the matter may be heard.
Yes, your lordship can pass the similar order because that has been already decided.
Should order pass similar order? We have gone through this.
We will contest before the learned honorable single judgment.
No, this is not. This is the impending order has been set aside. A request may be made to the criminal cause. There is also criminal case.
Yes, that is the women's case is pending against him.
All right. What is the order of this?
That page 15, my lord. You also can find it from page 15.
Heard Mr. M.K. Kuntial and counsel appearing for the appellant. And what is your name?
S.S. Mahapatra.
And also Mr. S.S. Mahapatra and counsel appearing for the sole respondent. By means of this intercourt appeal, the order dated 16/9/2021 caused by the learned single judge in WPC number 27810/2021 has been challenged. So the challenged learned single judge is observed as follows. For the settled position of law, this court in disposal of the writ petition observes petitioner cannot suffer for the long pendency of the vigilance proceeding. It is also not known when the vigilance proceeding initiated in the year 2007 will come to an end. It is keeping in this view, this court is in disposal of the writ petition directs the Principal Secretary to the Government of Orissa, Housing and Urban Development Department, OP number 1, to give promotion to the petitioner to the rank of Executive Engineer Civil from the date of his juniors and batchmates got such promotion. However, the promotion of the petitioner as per the direction of the court shall be subject to the ultimate outcome of the vigilance proceeding. Vigilance proceeding means what? Is it a criminal case?
Yes, ma'am. That
further, it is also clarified that promotion given to the petitioner to the rank of the Deputy Executive Engineer Civil and shall not confer equity in the event, and he will ultimately lose the vigilance proceeding. And the exercise shall be completed within 4 weeks from the date of communication of this direction. It is also clarified that upon promotion, petitioner shall also be entitled to all consequential benefits. Stop. Mr. Kunti, learned counsel, the additional government advocate has submitted that almost in a similar fact and circumstances, this court in a series of writ appeals, being WA number 805 of 2021, State of Orissa and another versus Joseph Bari, WA number 490 of 2021, State of Orissa and another versus Soisab Kumar Mandal and another, WA number 935 of 2021, State of Orissa versus B. Noreen Kumar Reddy and others, WA number 943 of 2021, State of Orissa versus Nikhil Mohan Bastia. This just all these terms, just copy I'm giving you this. Just the first case and others, just do the Joseph Bari and others, these analogous appeals have observed that the law as explained by the Apex Court in Union of India versus KV Janki Raman, 1991 4 SSC 109, State of Punjab versus Chamanlal Goel, 1995 2 SSC 570, and the judgment of this court in State of Orissa versus Somnath Sahu, judgment dated 26th April 2017 in WPC number 22393 of 2015. 19909 of 2015 WPC number. And the State of Orissa versus Anil Kumar Sethi, judgment dated 26th, earlier is 5th October, earlier 26th April 2017 in WPC number 22393 of 2015. It has been observed that there is no right the government servants to be considered for promotion during the pendency of either departmental proceeding or criminal proceedings or both against the government servant. So finally, it has been impugned. Finally, the order of the learned single judge has been set aside, whereby the single judge has directed that the regular promotion should be given to the writ petitioner within the respondent in the said appeal, subject to condition that the such promotion shall be given subject to outcome of the criminal case within the vigilant case against the government servant. So we are in total disagreement of the said the disagreement with the said view as taken in the Joseph Bari Sopra, and as such, we allow this appeal and allow this appeal set aside the impugned order dated 15/9/2021, passed in WPC numbers 27810/2021, right, Mr. Kunti?
Yes.
Stop. It is open to the respondent writ petitioners to take all actions so that the proceeding before the criminal court be expedited, so that the trial is taken to its logical end. Stop. The appeals, therefore, is disposed of.
With due respect, my lord.
While an affidavit, learned counsel, this is not done. You have observed our view. You have committed a series of further action where we have lost faith on you. File an affidavit. Express your remorse that we can consider.